Yo, I'm back. Maybe this is better. Let me let me hope this is better. Join back in this live and let me know if you can see shit the right way. If you can, cool. We had some technical difficulties in the first part of the stream. Let me introduce myself again. This is the GMS show. I am your host, Black GMS. I am here to cover the Derek Chauvin trial, and today are the closing arguments in the trial. Um, and this is something that's going to determine how the jury sees Derek Chauvin, whether he is a murderer or whether he didn't mean to. We all know the answer to that. I'm not playing stupid. We all know the answer to that. But today is very important, and we need to get to this shit. And I want to make sure that we all are able to keep up with it as well. And like I said before, well, first and foremost, let me start with positivity, man. I'm hoping everybody started their day out right. I hope everybody's hustling, getting to the money. I hope everybody is doing everything they're supposed to do. I hope everybody's achieving their goals. All right. Now, this is a very important deal right now because me being somebody who lives in Minnesota, we gonna feel it the hardest when this verdict comes out, whether it's favorable to George Floyd and his family or not. I will tell you, if the verdict comes back that he's guilty, it is gonna be it's gonna be a very great day for Minnesota. It's gonna be a celebration. It's gonna be a victory. I'm pretty sure George Floyd Square is going to be immaculate. Everybody there is going to be in just great spirits, and everybody's going to be joyful. It won't stop the fight to now, fight for justice for Dante Wright and everybody else who has been senselessly killed by the police over the years. But something like that is just, how vocal we have been and how strong we have been and how resilient and powerful our voices and our in the movement to push the fact that Black lives do matter, the fact that is happening. It's a good feeling to know that this could possibly come out the way that we want it to be. Now, we do have to realize that we do live in America, and that the reason why there is even a saying Black Lives Matter is because of the simple fact that our lives haven't historically mattered to anybody in this country. And it has been proven to us and shoved in our faces over and over again. The justice system spits on us at close range every chance they get. So I wouldn't put it past I wouldn't put it past them to do something to where they know their hate for us is so strong that they wouldn't even care about the entire fucking state burning down just so they can get what they want. You understand what I mean? Like people, like white supremacy and racism is that strong in them. Now, I'm not talking about anybody specific on the screen, but I'm talking about just in general. White supremacy and racism is so strong that even the thought of cities burning down across America wouldn't matter to them as long as they continue to remind us how much they don't give a fuck about us. So now I'm just hoping that, everything goes right, man, and I'm about to turn these closing arguments on. Like I said in the previous video before I came back on, this is different. I may pause when the defense come up. I'm not gonna pause it all for prosecution because I know they're gonna be on point. But if something I hear isn't right, I'm gonna comment on it. So I'm just gonna let y'all know. So if you want to watch just the live video by itself and watch it straight through, go to Washington Post and go watch them. But if you want to fuck with GMS and you fuck with my opinion on certain shit, stay right here, man. So I appreciate y'all. Thank you.
Counsel.
Shout out Raven. Shout out Brim. What's good? Bad Seed.
Members of the jury.
JG. Joe Blast. Casino. What's happening? JR, what's up?
His name was George Perry Floyd Jr., and he was born on October 14, 1973, in Fayetteville, North Carolina.
Say his name.
To his parents, George Floyd Sr. and Larcinia Jones Floyd, Sissy, the matriarch. Now, you met George Floyd's brother, Philonis, and you heard all about Sissy Floyd. She was George Floyd's mom. She was the mom of the house. She was the mom of the neighborhood. And you heard about the special bond that she and George Floyd shared during his life.
What's good, Elma?
You heard about their relationship, how he would always take time, special attention to be with his mother, how he would still cuddle with her in the fetal position. You heard that. And from George Floyd's brother, you learned all about George's childhood. And during his time growing up in that house, George Floyd was surrounded by people he knew, people who knew him, people he recognized, a familiar face to pick out in the crowd. People need that. George Floyd was surrounded by people he cared about and who cared about him throughout his life, throughout his childhood in that house, through his adolescence, into his adulthood. On May 25, 2020, George Floyd died, face down on the pavement, right on 38th in Chicago, in Minneapolis. Nine minutes and 29 seconds. 9 minutes and 29 seconds. During this time, George Floyd struggled, desperate to breathe, to make enough room in his chest to breathe. But the force was too much. He was trapped. He was trapped with the unyielding pavement underneath him, as unyielding as the men who held him down, pushing him. A knee to the neck, a knee to the back, twisting his fingers, holding his legs for 9 minutes and 29 seconds, the defendant's weight on him. The lungs in his chest unable to expand because there wasn't enough room to breathe. George Floyd tried. He pushed his bare shoulder against the pavement to lift himself, to give his chest, to give his lungs enough room in his chest to breathe, with the pavement tearing into his bare skin. As he desperately pushed with his knuckles to make space so he'd have room to breathe, the pavement lacerating his knuckles. The defendant stayed on top of him for 9 minutes and 29 seconds. So desperate to breathe, he pushed with his face, to lift himself, to open his chest, to give his lungs room to breathe. The pavement tearing into his skin, George Floyd losing strength. Not superhuman strength. There was no superhuman strength that day. There's no superhuman strength because there's no such thing as a superhuman. Those exist in comic books. And 38th in Chicago is a very real place.
That's love, Elmo.
Not
Appreciate you.
superhumans.
Thank you.
Only humans. Just a human, just a man, lying on the pavement, being pressed upon, desperately crying out. A grown man crying out for his mother. A human being.
You speaking for you speaking facts, are you?
In that place, while he was surrounded in life by people he knew him, faces he could pick out, there was no one there he knew. He was surrounded by strangers. Strangers, all of them. 9 minutes and 29 seconds. He's surrounded by strangers, not a familiar face to say his final words. But he did say them to someone. He said them to someone who he did not know by name, but he knew him from the uniform he wore and the badge he wore. And he called him Mr. Officer. That's what he called him, Mr. Officer. Mr. Officer would help. We call the police when we need help. And he pleaded with Mr. Officer. George Floyd's final words on May 25, 2020 were, "Please, I can't breathe." And he said those words to Mr. Officer. He said those words to the defendant.
Let it be known.
He asked for help with his very last breath. But Mr. Officer did not help. The defendant did not help. He stayed on top of him, continued to push him down, to grind his knees, to twist his hand, to twist his fingers into the handcuffs that bound him, looking at him, staring down at times the horrified bystanders who had gathered and watched this unfold. The motto of the Minneapolis Police Department is to protect with courage and to serve with compassion. But George Floyd was not a threat to anyone. He wasn't trying to hurt anyone. He wasn't trying to do anything to anyone. Facing George Floyd that day, that did not require 1 ounce of courage, and none was shown on that day. No courage was required. All that was required was a little compassion. And none was shown on that day.
Yeah, it's going to be hard to listen
George
to.
Floyd said,
I can't lie.
"I'm not trying to win." This was a call about a counterfeit $20 bill. All that was required was some compassion. Humans need that. People need that. But more fundamental than that, and more practical at that time, in that place, what George Floyd needed was some oxygen. That's what he needed. He needed to breathe. Because people need that. Humans need that.
What's up,
To
Ishbek?
breathe. And he said that. And the defendant heard him say that. Over and over. He heard him, but he just didn't listen. He continued to push him down, to grind into him, to shimmy, to twist his hand for 9 minutes and 29 seconds. He begged, George Floyd begged until he could speak no more, and the defendant continued this assault. When he was unable to speak, the defendant continued. When he was unable to breathe, the defendant continued beyond the point that he had a pulse. Beyond the point that he had a pulse, the defendant continued this assault. 9 minutes and 29 seconds. When the ambulance arrived, the ambulance was here, and the defendant continued. He stayed on top of him. He would not get up. He would not let up. He stayed on him, grinding into him, continuing to twist his fingers, to hold him down. He had no pulse. He was not breathing. He was not responsive, and the defendant had to know what was right beneath him? Right beneath him. You saw the video. You saw the point when the ambulance arrived, and finally, after a paramedic got out, and the defendant still did not get up, and the paramedic tapped him, and finally the defendant got up, and they lifted Mr. Floyd onto that gurney, and you saw the way he was not, there was nothing there. His head had to be held to prevent it from falling to the ground. He was completely limp. The defendant had to know that. He was there. He was on top of him. And he was on top of him. On top of him. Sometimes you ask for the truth, sometimes you insist on the truth. And the truth is the defendant was on top of him for 9 minutes and 29 seconds. And he had to know. He had to know. The medical examiner would find the cause of George Floyd's death to be cardiopulmonary arrest, complicating law enforcement subdual, restraint, and neck compression. Well, what you saw the defendant and the other officers doing to George Floyd caused his death. The medical examiner ruled the death a homicide, death at the hands of another. What the defendant did,
homicide,
to George Floyd,
stop playing,
killed him. It was ruled a homicide. The defendant is charged with murder. He's charged with murder and he's charged with manslaughter. The defendant at the time was a police officer. Okay? It may be hard. It may be hard for any of you to imagine a police officer doing something like this.
Not me.
In jury
not
selection,
us.
And we talked about bias, and we talked about setting biases and preconceived notions behind. Well, imagining a police officer committing a crime might be the most difficult thing you have to set aside, because that's just not the way we think of police officers. We trust the police. We trust the police to help us. We believe the police are going to respond to our call for help. We believe they're going to listen to us. And this is strong. This runs deep. I'd say it's difficult to set this aside. I want you to consider that even after with the bystanders, after they saw what they saw, after they saw this shocking display of abuse of police power and a man murdered in front of them, Genevieve Hansen, she called the police. Donald Williams, he saw this. You heard him. He testified. He called the police. A 9-year-old. Judea. What did she suggest? We need to call the police on the police. That's our expectation, even after seeing this, even after witnessing this. Our expectation is that the police are going to help.
It's a fact, Elma.
And with reason, and with good reason, right? Because policing is a most noble profession. It is. It is. And to be very clear, this case is called the State of Minnesota versus Derek Chauvin. This case is not called the State of Minnesota versus the police. It is not. Policing is a noble profession, and it is a profession. You met several Minneapolis police officers during this trial. You met them. They took the stand. They testified. Make no mistake, this is not a prosecution of the police. It is a prosecution of the defendant. And there's nothing worse for good police than a bad police who doesn't follow the rules, who doesn't follow procedure, who doesn't follow training, who ignores the policies of the department, the motto of the department, to protect with courage, to serve with compassion. Chief Arredondo, the chief of police in Minneapolis Police Department, he took the stand and he testified and he told you what that badge that he wears over his heart means. It's a public service. It's a public trust. They're there to help us. It's a professional organization. There are standards. There are rules. There's a code of conduct. There's a use of force policy. There's extensive training. The police are first responders. They're who we call for help, and they help us. They have CPR training. There's more training than simply use of force. There's more to policing than putting handcuffs on people and hauling them away, to be true.
Yeah, sorry, 1 second. Let me make that clear. Calling the police on the police, think about that. Like, forget the older gentleman who called the police on the police. He already understands what that's like. But a 9-year-old girl who feels like she has to call the police on the police, think about the traumatic shit that she'll have to go through with that. Not only seeing George Floyd die in front of her, but thinking that she has to call the police on the police. It's like you calling the murderers for help. Why would she call the police in the future, knowing that they do shit like this? And if he got away with it and he was acquitted, why the fuck would she trust the police going on from there? There's traumas behind this shit.
Right? There's other kinds of training. There's procedural justice. There's crisis intervention training. There's medical training. And there's defensive tactics. And there's de-escalation. All of this training. Hundreds of hours of training. You met the people who staff the training center, and they told you, we don't train this. They told you that. The sanctity of life and the protection of the public, those are the cornerstones of Minneapolis Police Department's use of force policy. The protection of the public, all of the human beings that make up the public. The defendant, he didn't do that because that day his badge just wasn't in the right place.
Fuck him and his badge.
The defendant was a police officer. He was. And again, you need to set aside the notion that it's impossible for a police officer to do something like this. The defendant is on trial not for being a police officer. It's not the state versus the police. He's not on trial for who he was. He's on trial for what he did. That is what he did. That is what he did on that day. 9 minutes and 29 seconds. That is what he did. He didn't follow training, those hundreds of hours of training that he had. He did not follow the department's use of force rules. He did not perform CPR. He knew better. He just didn't do better. He just didn't do better. Remember during opening statement, counsel said that the defendant followed the rules and followed his training. Did you hear evidence of that?
That's crazy, Raven.
Did you hear evidence of that from the stand? Or did you hear something quite different? The chief of police testified. He violated their use of force policy. He violated their de-escalation policy. He violated the duty to render emergency aid. No. You heard the trainer, Lieutenant Mercil. We don't train this. This is not who we are. No. That representation was simply wrong. That's just a story. What the defendant did was not policing. What the defendant did was an assault.
Murder.
I'm going to discuss the law with you in a bit here and explain. The court's already provided you some instructions on second-degree murder, and you know, done in the laws of this state, if you commit a certain level of assault, a felony level assault, and a person dies as a result of your assault, you're guilty of murder. It's as simple as that. And what the defendant did here was a straight-up felony assault. This was not policing. It was unnecessary. It was gratuitous. It was disproportionate. And he did it on purpose. No question. This was not an accident. He did not trip and fall and find himself upon George Floyd's knee and neck. He did what he did on purpose. And it killed George Floyd. That force for 9 minutes and 29 seconds, that killed George Floyd. He betrayed the badge.
Appreciate you, Dip.
And everything it stood for. It's not how they're trained. It's not following the rules. This is not an anti-police prosecution. It's a pro-police prosecution. The defendant abandoned his values, abandoned the training, and killed a man. And why?
What up, Sean?
Right out in the public, right out in broad daylight, in front of several bystanders as they looked in shock and horror. And why? Well, this all started over a call of an alleged counterfeit $20 bill.
Hold on, I gotta
But
block my
George
screen for
Floyd's
2 seconds.
life was taken for something worth far, far less. Far less. You saw the photo. You saw the body language. You can learn a lot about someone by looking at their body language. The defendant facing down that crowd. They were pointing cameras at him, recording him, telling him what to do, challenging his authority, his ego, his pride. Not the kind of pride that makes you do better, be better. The kind of ego-based pride. But the defendant was not going to be told what to do. He was not going to let these bystanders tell him what to do. He was going to do what he wanted, how he wanted, for as long as he wanted. And there was nothing they could do about it because he had the authority. He had the power of the badge and the other officers. And the bystanders were powerless. They were powerless to do a thing. The defendant, he chose pride over policing. Remember, Charles McMillan, 61 years old, interesting man. Right? You remember when he testified, he had the glasses. If any of you in the front row, when he walked by, happened to notice his shoes, if you looked at his shoes, you probably saw your reflection in those shoes, right? He dressed for court like it was the most important day of his life. Interesting man.
He said my man was sharp.
He was there. He's sort of narrating this horrific scene throughout. You hear him in the video. And he called out to George Floyd. He said, you can't win. You can't win. And George Floyd replied, I'm not trying to win. I'm not trying to win. I'm scared. But the defendant was trying to win. He wasn't going to be told what to do. He wasn't going to take a challenge to his authority. He was trying to win. And George Floyd paid for it with his life.
Whew. Prosecution is getting in him right now.
Also need to be clear, this is not the trial of George Floyd. George Floyd is not on trial here. You've heard some things about George Floyd, that he struggled with drug addiction, that he was being investigated for allegedly passing a fake $20 bill, that there was never any evidence introduced that he knew was fake in the first place. Right? But he is not on trial. He didn't get a trial when he was alive.
I see you, JG.
And he is not on trial here. Defense claims that he was non-compliant. Non-compliant. Well, let's revisit what happened before the 9 minutes and 29 seconds. Before that, it's Memorial Day, right? May 25, 2020, and George Floyd is sitting in a car in the driver's seat with two friends. Now, previously he'd been in Cup Foods. He'd been in the store. He was walking. He was talking. He was breathing. As alive as any person, any human in this room.
Facts.
Back to the car. He's with his friends, and there's a tap at the window. He looks to his left and is startled. This is what he sees. This is what he sees. within seconds of the approach. Officer Lane have tapped on the window. Within seconds, he pulls his gun and holds it inches from George Floyd's face and starts shouting profanities. Show me your effing hands. Show me your effing hands. Screaming it. This is within seconds. You can tell a lot about someone by looking at their body language.
You would have thought George
How
had a
does
gun
Mr.
on him.
Floyd look in this photo? Terrified? An officer on the driver's side, an officer on the passenger side. Lane orders Floyd to put his hands on the steering wheel. He does. That's not resistance, that's compliance. Lane orders Floyd to get out of the car. He does. That's not resistance, that's compliance. They order him, they want him handcuffed. He is handcuffed. That's not resistance, that's compliance. And on the handcuffs, you recall the testimony, they weren't properly double locked. And so they continue to ratchet. They're not on correctly, they're on too tight. Throughout, and you listen to the videos, throughout the videos, you can hear the sound of those handcuffs ratcheting tighter and tighter. Mr. Floyd is trying to explain to the police that his wrists hurt. Impervious of pain. Please. His wrists hurt. No one listens to him. But it continues. They tell him to go over to the Dragon Walk. He goes over to the Dragon Walk. That's not resistance, that's compliance. They ask him to sit down. He sits down. Not resistance, compliance. Not trying to escape, not trying to evade arrest, not trying to assault anybody, shoot anybody, stab anybody, punch anybody. No. Compliance. Sits down on the ground. They ask him his name. He gives his name. He spells it. That's not resistance, that's compliance. They ask him to get up, he gets up. They ask him to go across the street, he goes across the street.
I can't lie, I'm getting angry
Where's
as
the
fuck right
resistance? Where's that?
now. I gotta roll up. I wasn't trying to smoke nothing on this, but
They
I
take him
have
over to the car.
I'm
Okay?
mad.
They take him over to the car. George Floyd is a big guy. Right? You can see here, I mean, he's almost as big as Officer Lane. He's a big guy. He's a big person. The back of the squad car is not. Right? That's what they wanted him to get into. And to George Floyd, he looked at that. What do you think that looked like? Like a little cage. Right? He tried to explain himself to the officers that he had anxiety, that he had claustrophobia. He explained this over and over. They wanted him to get in the back of this little car. And you know, he just wasn't able to bring himself to do it. He wasn't able to bring himself to do it.
Man, I'm scared as fuck, man. If I start breathing, it's gonna go off on me, man.
Pull your legs in.
Okay. Let me count to three. Let me count to three and I'm going in. Please.
So he's trying to work up the ability to get in the car. He's explaining himself repeatedly. And you can see this is where the defendant and Officer Tao start coming into the scene. Right? And we'll look at what they saw in a minute. But they start to come to the scene. Right? A 19-year veteran of the police force with all of the training that involves, over 800 hours of training, 40-hour crisis intervention training course, with scenario-based training where they're taught to recognize the signs of someone who is experiencing a crisis. A crisis. You know, he couldn't bring himself to get in, and sometimes people can't bring themselves to get in. And this is not new. This is not groundbreaking. Okay? People have emotions. People have things happen to them. The police train for this. They recognize this. You don't get to meet the police on your best day very often. You don't call the police and say everything's fine, just wanted you to know, right? That doesn't happen. Okay? No, there's a whole range of humanity out there who have a whole range of different issues. I mean, it could be anything. It could be a death in the family. Right? That can cause an extreme emotional response. You know, recall when Officer Lane approached the car, George Floyd talked about losing his mother. He'd lost her in 2018. Those wounds still right there on the surface. Emotion. It could involve a divorce, finding bad financial news, right? Mental illness, mental health issues, like drug and alcohol abuse. All of those things can cause someone to not resist, but just not be able to bring themselves to comply at that moment, at that time. And this is nothing new. They train for it, they plan for it, they prepare for it, they have a policy on it, right? Recognizing persons in crisis. You remember Chief Arredondo took the stand. He testified that they have 4,000 calls for service for persons in crisis every single year. This is nothing new. They're there on a $20
I'm gonna check that out, Anthony.
charge. They train for this. They know about this. Now, George Floyd certainly had his struggles. You know that. The state put in evidence of that. Right? Courtney Ross testified that he struggled with an opioid addiction. You knew that. And this is nothing new. The difference, though, on May 25, 2020, the officers just wouldn't listen to him, wouldn't look at the signs, wouldn't recognize the signs of what they had prepared for. And a reasonable officer in the defendant's place, with all his training and all his experience, including that 40-hour crisis intervention course and a subsequent refresher course, should have known that and should have recognized it. Floyd was trying to get into the car. He was trying to work up the courage. He said he'd count to 3. But he just couldn't do it. So the defendant arrives on the scene. He surveys the scene. He saunters up to the car, and he slips on his gloves.
You can't win, bro. You can't win. I'm not trying to win. Go on, get in the car then. I'll be on the ground, anything. Go on, get in the car. He know it. He know it, Mr. Officer. Y'all hear me? Don't do me like that, man. Please. Okay, can I talk to you, please? So you get in this car, we can talk. I am claustrophobic. I'm hearing you, but you're not working with me. God, I'm claustrophobic right there, man. Get in the car. Get me in the front. Please. No, you're not in the front. I'm claustrophobic, Mr. Officer. Get in the car. We're going to pull you in. Okay. I'm not a bad guy, man. Get in the car. I'm not a bad guy. You ain't gonna win.
So they don't listen. They just shove him into the car, into that tiny back seat. You saw the look on his face. You saw the look on George Floyd's face when he glanced over into that car. Looked like he'd...
Full disclaimer, anybody, if you see, if any trolls pop up, because they seem to do, 1 or 2 seem to pop up every stream. If you see them, I'm not finna deal with them. Y'all can deal with them.
Seen a monster.
If y'all want.
Looking into that car. Clearly, this trained officer should have recognized that and understood at that moment and that time, well, what is your goal? Where'd this critical thinking model go? Where'd that go? Where you take in information, you assess the information, you reassess the information, you consider what's the goal, what's the plan. You're there for a $20 counterfeiting charge, allegedly. Chief Arredondo testified they generally don't put people in custody for that. So why is it necessary to shove them in the car? They made a judgment call. They decided to shove him in the car. The predictable thing to happen happened, right? He just couldn't be in the back of that car. And so they pull him out. They pull him out. And watch what happens. They pull him out of the car.
What? Please, man.
Here, come on out.
Look at you. Thank you. Thank you.
Get him down on the ground. Yeah, on the ground. On the ground.
My wrist. Ah. Look at you. Thank 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 you.
All right, folks. They get him out of the car. He is handcuffed. He is on his knees. He is not going anywhere. There are 4 officers there. 4 officers. And what did George Floyd say once they pulled him out of the car?
Look out.
Thank you. Thank you. Now, a reasonable officer in the defendant's position at that time should have recognized and understood he wasn't trying to escape. He wasn't trying to punch anyone, stab anyone.
What the fuck is he still
He
writing?
wasn't trying to do that. The
These are
problem
the closing arguments.
was the back of
And
the
you
car.
pled the fifth.
Just like George Floyd tried to
Fucking
explain.
bitch, put the fucking pen down and
over
listen.
and
Piece
over.
of fucking
The problem
shit.
was the
I
back
hate
of the
this
car.
nigga.
So if you can give them the benefit of the doubt that they made a bad judgment call and shoved him in the back of the car, at least when he came out in the struggle, it was over. He was on his knees. He was saying thank you. Done. No need. It could have been over there. But what did they do? They took him from this position, handcuffed on his knees.
It's a good clip.
They pushed him down onto the ground. Didn't need to. Not at all. For what?
I hope, man.
He's handcuffed. They pushed him down into what is, you now know, from watching the evidence in this case, the prone recovery position. Right? When he's down on the ground, he's initially pushed, he is literally in the prone recovery position on the side. That allows the chest to expand and provides room for the lungs to expand and take in air so they can breathe. That is a step that protects against the known danger of positional asphyxia. And they have him there. He's right there. So then what happens after? They take him
This nigga Cliff said, Caucasus Mountain Monster.
incredibly out of the recovery position and prone him on the ground.
I needed that laugh.
For what?
Thank you.
The prone position is a transitory position. It's a position you use to secure someone in handcuffs, and when you're done with that, you immediately roll them on their side. Right? That's the position he was in. Proning him was completely unnecessary. And this is where the excessive force begins. Right? This is where the 9 minutes and 29 seconds start, because they didn't just lay him prone. They did not do that. They stayed on top of him with a knee on the neck and a knee on the back, and the defendant's weight on Mr. Floyd, pushing down with
Thanks,
Officer
Anthony.
King adding to the pressure, pushing down, holding his feet, Officer Lane holding his feet for 9 minutes and 29 seconds. That's when the excessive force began. That's when the countdown began. Now, you need to sort of pull back and take a look. You've learned a lot about policies and procedures and tactics. You have to pull back and say, would, but for the defendant's actions, pushing him down, would George Floyd have died that day? Was it drugs? He just miraculously die of a drug overdose in that time? Maybe it was the tailpipe. Maybe it was his enlarged heart. Maybe not. Use your common sense.
Facts.
Use
Come
your
on,
common
bruh.
sense.
Say that
Believe
shit.
your eyes. What you saw, you saw.
Come on. Like, what the fuck are we talking about?
Now, I'm going to talk to you a little bit about the law. The judge has already instructed you. And it's necessary to go over this a couple of times. You've learned you've gotten to go to medical school here as jurors. There's so many benefits to being a jury. You got to go to medical school. You got that free parking, great lunches, fabulous pay. So now you get a little bit of a free law school education. The judge gave you a preview of that. We're gonna go through that again. He's going to give you a copy of those instructions. You have them. You get to keep those and use those during your jury deliberations. He told you that you don't have to decide these issues in any order. You can do it the way you all see fit. I'll be making some suggestions as to the order I think you should do things. It might focus your deliberations and just make the conversation a little easier, a little more focused. But you have these jury instructions as your guide. I think it's important for you to follow the judge's instructions to the letter, right? The words and the definitions that the judge gives you.
That speaks to that condition,
the judge
Anthony.
says they mean. And know that the state is required to prove these charges beyond a reasonable doubt. Proof beyond a reasonable doubt. He read this to you. Proof beyond a reasonable doubt is proof as ordinarily prudent men and women would act upon in their most important affairs. And a reasonable doubt is based on reason and common sense, not a fanciful or capricious doubt or beyond all possibility of doubt. So reasonable doubt, it's just as the name implies. It's a doubt that's reasonable, a doubt based on reason and common sense. You as jurors are not required, nor should you, leave your common sense at the courthouse steps. As jurors, you must rely on your common sense. That's why you're here. We need you to apply that standard to these facts and to be a judge of the facts and apply those facts and findings of facts to the law. And so proof beyond a reasonable doubt, it certainly is a high standard. It's the highest standard. It's a standard that the state has met here. And the state does not need to prove its case beyond all doubt. It does not need to prove its case beyond what I'll call an unreasonable doubt. Not required to prove beyond an unreasonable doubt. An unreasonable doubt is a doubt not based on common sense, but based on nonsense. And you're not required to accept nonsense. You're not required to accept the notion that after the defendant kneeling on Mr. Floyd for 9 minutes and 29 seconds in the dangerous prone position, handcuffed, restrained, pressing down on him, that after that, as he was writhing in pain and suffering, that's not even a use of force. Right? There's no force there because it's not likely to produce pain. A witness testified to that. You're not required to believe something that just flies in the face of common sense, to believe that you would have to completely abandon all notion of common sense, not likely to produce pain. You don't have to accept someone who says that. You'd be better off asking the 9-year-old.
The fuck?
You're not required to accept the proposition that the car did it, that the car killed George Floyd. You're not required to accept that or to consider that it is the bystander's fault for distracting the defendant. You're not required to believe this amazing coincidence that after this 9-minute and 29-second prone restraint, that at that point in time, even though he was walking and talking, even though he was breathing, interacting with people, that he chose that moment to die of heart disease? To die of heart disease? Is that common sense or is that nonsense? Or that it was a drug overdose?
I personally find it to be a load of malarkey.
You know that George Floyd struggled with drug addiction and drug use. You know that. You know he had developed that requires a tolerance. You know what the toxicology report says in terms of the levels, and you know what the testimony
that shit was fucking
about
stupid.
That. Die of a drug overdose. It's not common sense. That's nonsense. Believe your eyes. What you saw happened. It happened. The defendant pressed down on George Floyd, so his lungs did not have the room to breathe. Dr. Tobin told you that. Dr. Smock, Dr. Rich, the experts who testified, you can rely on them. Dr. Smock, Dr. Rich, Dr. Eisenschmidt. It's like that commercial, right? They know a thing or two because they've seen a thing or two. They know a thing or two. Dr. Tobin knows a thing or two about how this works.
That's why I'm doing this, Ben Slim.
So, looking at
pay attention to what Ben Slim just said. Read what Ben Slim just said, and y'all know why I'm doing this right now. So I appreciate that. I'm glad you see that.
Charges, and this is a little bit of a different layout than you see in your printed jury instructions.
Definitely don't want to watch this by myself.
Intended to replicate the instructions completely. But it's meant to be sort of a guide for you to look at the different elements in a particular context. And so the charge of murder in the second degree, murder in the third degree, manslaughter in the second degree, the judge read you what the law says those things are. And the law breaks down these different charges into things called elements. First element, second element, third element, fourth element. And each of these has to be proved beyond a reasonable doubt by the state in order for the defendant to be guilty of those charges. Now, those are the elements that are required. Those are the only elements that are required. Again, like other preconceived notions, you may have some ideas, from watching TV about other cases and shows and things. You might have some other ideas as to what the law requires. But again, just like it's how it's lunchtime in court. The judge tells you it's lunchtime. When it's time to go, the judge tells you it's time to go. Same thing. You know what the charges are. You know what the elements are because the judge tells you what the elements are. So you need to follow that. Okay? So talking about murder in the second degree, first, the death of George Floyd must be proved. Right? And then it must be proved that the defendant caused the death of George Floyd. And the fact that other causes may have contributed to George Floyd's death does not relieve the defendant of any criminal liability.
Facts.
It just does not.
Come on.
And for murder in the second degree, that the defendant at the time of causing George Floyd's death was committing or attempting to commit assault in the third degree. That's a felony level assault under the laws of Minnesota. And assault, to show the defendant assaulted George Floyd, that he intentionally applied unlawful force to Mr. Floyd without Mr. Floyd's consent, resulting in bodily harm. The state has to show that. The state did show that.
Whoops.
The assault. And that the defendant inflicted substantial bodily harm on George Floyd. And that this act took place on or about May 25, 2020 in Hennepin County. Okay, so as to the first element, that George Floyd died, well, that was established. That was established by the emergency room physician, Dr. Langenfield. George Floyd was pronounced dead at the Hennepin County Memorial Hospital on May 25, 2020. So that element is met. And again, you can consider these elements any way you want to consider them. My suggestion is that you consider them in the order as listed here: murder 2, murder 3, manslaughter in the second degree, and in order of the elements, just because there's a lot here. There were 38 witnesses who testified. There are a lot of exhibits that were offered, and it's easy to talk about everything at the same time. It really is. But it will help focus your deliberations if you look at these different elements in order to have sort of a logical way to focus your deliberation. So I encourage you to do that, but you can do it any way you want. Okay. Second element, that the defendant caused the death of George Floyd. Okay. Causation. So what does that mean? What does causation mean here? It means that the defendant's act or acts were a substantial causal factor in causing the death. He's criminally liable for all of the consequences of his actions that naturally occur, right? Including those consequences brought about by intervening causes. The fact that other causes may have contributed to George Floyd's death just does not relieve the defendant of criminal liability.
I'm glad he's breaking this shit
You
down.
have to find is that 9 minutes and 29 seconds of compression on his knee, with his knees on his neck and on his back, being held down, was a substantial factor in George Floyd's death. Now, if there was a superseding cause, then the defendant wouldn't be criminally liable. But the superseding cause, those are causes that come after the defendant's acts and alters the natural sequences of events, and is the sole cause of death. And we don't have that here. So we know how George Floyd died.
Don't be fucking up the audio now.
This is the use of force.
Come on now.
When we talk about use of force, that's been defined by the different witnesses who've testified, looking at what happened From the point, the knee went to the neck and back, right? And the unlawful restraint, the assault, started.
They made a
And how
thumbnail
long
out
it
of Derek
lasted,
Chauvin.
9
That's
minutes
crazy.
and 29 seconds. That's what that's what killed George Floyd. That's why he died. Believe your eyes, that unreasonable force pinning him to the ground, that's what killed him. This was a homicide. Oh, you heard this from forensic pathologists, the experts. You've heard this, and the experts have weighed in. And Dr. Langenfield told you that Mr. Floyd died. Dr. Baker ruled this a homicide. And told you the cause and manner of death, the unlawful, the restraint and subdual by law enforcement. What they did killed him. Told you that. Dr. Tobin, remember Dr. Tobin? He told you specifically how it happened. He walked you through that, the asphyxia. Right? He told you how it happened. And the other doctors who testified, Dr. Smock, Dr. Rich, Dr. Eisenschmidt, they told you how it didn't happen. Right? It wasn't a sudden cardiac event. It wasn't a heart attack. It wasn't a drug overdose. Right? It wasn't any of those things. Right? Dr. Tobin came back and explained it wasn't carbon monoxide. Right? No. So you know how George Floyd died, and you heard this. But specifically, Dr. Tobin provided fairly extensive detail and was very clear that George Floyd died as a result of a low level of oxygen. This low level of oxygen caused a brain injury and a PEA arrhythmia, which caused his heart to stop. That's not a cardiac event. It's not that his heart disease, right, that didn't cause him to die. It was the low level of oxygen. It was the asphyxia that caused him to die. Right? And we know that happened. We know that happened because they observed during the restraint at 20:24:21, right? What they observed? They observed an anoxic seizure, right? A telltale sign of oxygen deprivation. Dr. Tobin told you that. Even Dr. Fowler told you that. And after Mr. Floyd experienced a seizure, he passed out. After his pulse stopped, his heart stopped. That cardiopulmonary arrest, that was the result of the police subdual and the restraint and the neck compression. We know from Dr. Tobin, George Floyd did not die primarily from a cardiac event, as has been suggested. Now, George Floyd, he was not in perfect health. Sure, he had narrowed arteries, high blood pressure, no question about that. He was experiencing stress, even before the officers shoved him onto the sidewalk unnecessarily, gratuitously, disproportionately. But none of this caused George Floyd's heart to fail. It did not. His heart failed because the defendant's use of force, the 929, right, that deprived Mr. Floyd of the oxygen that he needed, that humans need to live. And Dr. Tobin knows because he is a pulmonologist. He's a lung doctor. He's a lung doctor. He's also a respiratory physiologist. He's the only person who testified who was able to calculate lung capacity, lung volume. Right? He could do that. Dr. Baker couldn't do it. Didn't do it. He deferred to the pulmonologist, Dr. Tobin.
That's heavy, Joe.
Dr. Fowler couldn't do it. He said he would defer to a pulmonologist. And Dr. Tobin, who also happens to be a critical care physician, he spent years treating patients in intensive care who were experiencing respiratory failure. And Dr. Tobin literally wrote the book on the subject, and he was able to tell you, right, what this looks like, what he was able to observe. What he was able to observe was oxygen deprivation. It was asphyxia. It was asphyxia. Because under the conditions that Mr. Floyd was being restrained, that the defendant put him in, okay, that cut off his oxygen, it would have cut off oxygen of someone who is perfectly healthy, of anyone. The forces that were used in this situation, right, it involved multiple factors. George Floyd was handcuffed. He had impaired arms and chest movement. He was placed prone, shoved prone on the sidewalk, the knees pushing on his neck and back downward, the pavement, the force of the pavement being unyielding. It was like he was in a vice, that he was being, squeezed in a vice. And he calculated, right, between Chauvin, the defendant, Officer King, pushing down on him approximately 90 pounds of force. And the position and the force combined such that it was as if George Floyd's left lung had been surgically removed. That's how much of a reduction of air capacity there was here. To the point that Mr. Floyd was desperately trying to make space to breathe, pushing his shoulder, pushing his face against the pavement to lift up, to give space to breathe. His lung capacity, based on Dr. Tobin's calculation, had just being in the prone position.
No, I don't think so, Salva.
Even though you heard some studies from the defense saying, the prone position isn't dangerous. Well, Dr. Tobin disagreed. He said that the lung capacity was reduced by 24% just by the prone position, 43% when you consider the additional pressure. Now, Dr. Tobin's opinion corroborates the police training and what the police have known for 30 years. Right? That there's a danger to the prone position, and the danger is positional asphyxia. And the danger, the worst thing that can happen with positional asphyxia, is death. And it wasn't just the lungs, the pressing up against the neck. Remember when you touch that it reduced the capacity of airflow such that it was as if Mr. Floyd was breathing through a straw. Right? These shallow breaths did not produce enough oxygen. Not enough oxygen could get to the lungs. And that's what killed George Floyd. And here's what didn't, right? Here's what didn't. This wasn't a sudden cardiac arrhythmia, right? Dr. Smock told you that. Dr. Thomas, Dr. Rich, Dr. Tobin, they agree. Not a sudden cardiac arrhythmia. That's not how this looks. Dr. Baker, no medical evidence of a heart attack. Okay? We heard from Dr. Rich. Dr. Rich actually treats people who have heart attacks. And he found there was nothing in his review, nothing in George Floyd's heart to suggest that the death originated from the heart. Nothing. Over the course of this case, you heard a lot of things that didn't happen and hypotheticals that don't apply.
What ifs?
Right? You know why George Floyd died. You know how he died.
Look, they fucking up the audio for a reason,
drugs.
man.
You heard about his struggle with addiction. There's some things, George Floyd was obviously not a perfect man. Who is? No one is. Right? So you heard about drugs, some pills in the car, in the squad car, in his car. You heard questions about, is he chewing gum? Does he have a pill in his mouth based on this free? None of that matters. Because you know what his level, the drug level was. You know that from the toxicology report. If drugs are found in the...
Let me refresh this, because for some reason they trying to fuck up the audio, and now they trying to fuck up the video.
He didn't slow down.
There we go.
Right? He didn't fall asleep. He didn't go into a coma. No. This looked nothing like a fatal fentanyl overdose. Dr. Tobin, the only doctor in this case who actually calculated George Floyd's respiratory rate, and the best doctor to do so, given his training and given his experience, right, he stated that the fentanyl in George Floyd's system did not depress his respiration. It didn't. He did not die of a drug overdose. That's not how he died. He didn't die of excited delirium. You heard about excited delirium. Right? Dr. Smock, who testified about excited delirium, told you, explained to you, George Floyd did not exhibit any of the signs of excited delirium.
Just
one of
stupid
which being
as fuck.
superhuman strength. Nonsense. There's no superhuman strength. There's no superhuman strength. There are no superhumans.
For real.
Impervious to pain. Nonsense. You heard him. You saw him. He was not impervious to pain. It's nonsense. Paraganglioma, suggestion that this tumor, which is literally called an incidental tumor, relatively rare, maybe causes headaches, that caused his death. At that particular moment in time, at that place, after the restraint, after the subdual, after the 9 minutes and 29 seconds, the tumor that causes headaches, that killed him? No. That's just a story. And Dr. Rich specifically testified that he looked in George Floyd's medical records and he did not find references to headaches. And you heard about...
He said excited delirium, never heard of that, because that's how far they'd reach just to try to prove that George Floyd didn't die of what we saw him die from. Like, it's ridiculous, man.
Carbon monoxide. The car killed him. Well, Dr. Tobin came back and explained, right, this car, which had a catalytic converter, that was outside, that was a hybrid, and there's no evidence was even on, right, that did not kill him. Right? He explained carbon monoxide saturation level, oxygen saturation level, and based on his calculation of oxygen saturation level at 98%, at most there could have been a 2% carbon monoxide, same as anybody else, same as people walking around, talking, breathing. Right? This wasn't carbon monoxide. That's just a story, and it's simply wrong. You don't have to be Dr. Tobin to recognize this. It's probably nice to be Dr. Tobin, but you don't have to be Dr. Tobin to recognize this. You can see this with your own eyes. You could see what happened.
Shrimply pibbles.
That he couldn't breathe. He said he couldn't breathe. The defendant was on top of him, on his back, on his neck, with his knees pressing down. Of course. You saw how his body just sort of deflated into the ground, past the point of consciousness. There were multiple moments in time, ladies and gentlemen, multiple moments in time that things could have gone different, and George Floyd would have lived. CPR. If he would have left him in the side recovery position in the first place, or just placed him in the side recovery position shortly after the restraint, he wouldn't have died. Their own force witness testified that putting somebody in the side recovery position is pretty fast, pretty easy thing to do, not complicated. No. Professor Stoughton said you just rotate them 90 degrees, quick. Could have done that. Relieve the pressure. Could have done CPR, chest compressions. Was supposed to, had a policy he was supposed to follow. Right? A duty to provide medical aid. You're not just supposed to phone that in. You're actually supposed to use your training, provide the medical aid. Even Dr. Fowler was critical. No one starting CPR. Said that should have been done. Defendant knew how to do it. He had the training. He knew better. He just didn't do better. George Floyd didn't have to die that day. Shouldn't have died that day. But for the fact the defendant decided not to get up and not to let up, George Floyd died. And these actions were a substantial factor in George Floyd's death. And these actions, make no mistake, these actions were not policing. These actions were an assault.
Murder.
So, as the judge instructed you, for second-degree murder, and it's actually very simple, if you find that the defendant committed this third-degree assault, while committing the assault, he caused George Floyd's death, the defendant's guilty of murder. That's the way felony murder works in Minnesota.
Plain and simple.
So there are two elements.
If it was
That the
me, they
defendant
would have
assaulted
fucking
George
convicted
Floyd.
me
What does that
already.
mean? Assault is the intentional infliction of bodily harm upon another, or the attempt to do so. Intentional infliction of bodily harm, that requires proof that the defendant intentionally applied unlawful force to another person without that person's consent, and that the act resulted in bodily harm. intentional. He did it on purpose. He did the thing on purpose.
Yeah, pay attention, you little bitch.
Bodily harm, physical pain, illness, or impairment of a person's physical condition. So again, to be very, very clear, the state does not have to prove that the defendant had an intent to kill George Floyd. This was an intentional act that you see before you. He did this on purpose. And that's clear. He didn't, again, trip and fall and find himself there. And this was also unlawful force. Officers are only authorized by law to use reasonable force. And this was not reasonable force, as I'll explain. And George Floyd clearly did not consent to having the defendant's knee on top of him for 9 minutes and 29 seconds. When you hear someone gasping for breath, calling for their mother, begging you to get off, how could you think anything else? That he did not consent to this. Now, the state does not have to prove what we don't have to prove about intent. We don't have to show that the defendant intended to cause George Floyd harm. We don't have to show that. You don't need to find that the defendant was trying to cause harm or had the purpose to cause harm to conclude that this was an assault. You do not. The state doesn't have to show that the defendant intended to violate the law. We don't have to show that. We don't have to show that the defendant intended to kill him. The only thing that the only thing about defendant's intent that we have to prove is that he applied force to George Floyd on purpose, that this wasn't an accident, and it's pretty simple. You know, if you're doing something that hurts somebody and you know it and you keep doing it, you're doing it on purpose. Somebody's telling you they can't breathe and you keep doing it, you're doing it on purpose. What else is going to happen when you push somebody down on the pavement? Everybody knows this. Everybody knows what happens when you push somebody against the pavement. Right? You learn this pretty early on. We learn this pretty early on.
Whoa.
Assault in the third degree requires that the defendant inflicted substantial bodily harm on George Floyd. Right? Substantial bodily harm meaning a temporary but substantial loss or impairment of the function of a bodily member or organ. Organs, the lungs, the heart. Temporary loss of consciousness qualifies as substantial bodily harm. Certainly a permanent loss of consciousness would constitute substantial bodily harm. You look at this point in the restraint and you see the absence of expression, the absence of muscle tension. He's unconscious. He's lost consciousness. That's substantial bodily harm. He did that. That's his knee. So when you consider the charge of second-degree murder, try to break it down into parts and find an order. The defendant caused George Floyd's death. He did. The state proved that beyond a reasonable doubt. And at the time of causing the death, the defendant committed or was attempting an assault in the third degree. And that's been proved beyond a reasonable doubt. With those being proved in the venue, right, second-degree felony murder, the defendant is guilty. So going back and talking about murder in the third degree, you can see that there's some elements in common. Right? There's some differences. We've already discussed the first element, the death of George Floyd, the substantial causal factor with the second element, and then the fifth element about the venue element, I'll call it, May 25, 2020 in Hennepin County. So for third-degree murder, the difference for third-degree murder is that the defendant had to cause George Floyd's death by committing an act that was eminently dangerous and performed without regard for human life. And again, the state is not required for this charge either to show that the defendant intended to kill George Floyd, but he committed an act that was eminently dangerous and performed without regard for human life. And it must prove, the state must prove that the act was highly likely to cause death, that the defendant acted with a reckless disregard for human life, that he was consciously indifferent to loss of life that his actions could cause. The defendant's act was eminently dangerous to others. It was likely to cause death to Mr. Floyd. And as if common sense in and of itself would not suffice, the dangers of prone restraint, of positional asphyxia, has been known in the law enforcement community for about 30 years. Right? This is known, if common sense wasn't enough. Defendant's own use of force witness admits that. And again, when we talk about danger, what is the danger? What's the potential danger of positional asphyxia? It's death. Right? The medical experts who know a few things, who know a thing or two, right? Dr. Tobin, Dr. Smock, Dr. Rich, they agreed. Right? The defendant's actions created a high risk of death. And the defendant consciously disregarded the loss of life that his actions could cause and did cause. He knew the risks of positional asphyxia due to this position. Everybody in law enforcement knows that, but he had other warnings, not just from his training. He had other warnings from people.
He's not even resisting arrest right now,
I
bro.
agree, bro.
Pass out.
That's what happens on the ground. He's breathing right now, bro. You think that's cool? You think that's cool though, right? What's your badge number, bro? You think that's cool right now, bro? You think that's cool though, bro? You're a bum, bro. You're a bum for that. You're a bum for that, bro. You getting mad. You just sitting there stopping his breathing right now. The dude's about to go out right now, bro.
I wish I knew that man's Cash App.
It was plain and apparent to everyone who was there what was happening. He's going unresponsive. He's passed out. He's not talking. What are you doing? Now we know that the defendant chose not to listen to bystanders, not to these bystanders, but how about to fellow officers on the scene?
Roll him on the side.
Roll him on his side, staying put where we got him. That's what the defendant said. He's staying put where we got him. Roll him on his side means roll him into the side recovery position. He could have listened to the bystanders. He could have listened to fellow officers. He could have listened to his own training.
That
He knew
right
better.
there.
He just didn't do better. He knew
Put
that
that man
kneeling on
under.
somebody's neck, in addition to the positional asphyxia, just the pressure, is dangerous. Anyone can tell you that. A 9-year-old can tell you that, did tell you that. Conscious indifference? Indifference? Do you want to know what indifference is and sounds like?
I'm through. I'm claustrophobic. My stomach hurts. My neck hurts. Everything hurts. There's water or something. Please. Please. I can't breathe, officer.
There's a lot of talking, a lot of
They
yelling.
gonna kill me. They gonna kill me, man.
Takes a heck of a lot of oxygen to say that.
Come on, man.
Indifference.
Fucking taunting him while he's fucking dying.
Leisurely picking rocks out of the tire. Commenting about the smell of the man's feet, who you're pressing down, grinding on, as his voice slows and fades as he tells you, "You're gonna kill me." I can't breathe. My stomach hurts. My neck hurts. Everything hurts. It takes a lot of oxygen to complain about it.
I hope every single one of them officers dreams about that fucking moment every single night of their fucking life for the rest of their fucking life. Rest of their life. I hope they hear George Floyd's voice in their head for the rest of their fucking life. They can't sleep, they can't eat, they can't do shit without hearing that man's voice. I pray to God that is the case.
Indifference. Did the defendant ever listen? Ever consider medical attention? No one defended that decision, the failure to give CPR, not even Dr. Fowler. This isn't protection. This isn't courage. And it certainly is not and was not compassion. It was the opposite of that. So back to the instructions and the elements of third-degree murder. When you're deliberating, ask yourselves, did the defendant cause the death of George Floyd by an intentional act that was imminently dangerous to others? Absolutely. The state proved that. Did the defendant act with a mental state consisting of reckless disregard for human life, a conscious indifference to the loss of life that the eminently dangerous act could cause? Yes, he did. And you will find, based on that the state has proved the defendant
That's what happened,
is guilty of third-degree murder as charged. So back to the charges, let's talk about manslaughter in the second degree. And again, you can see that there's some elements in common. The first, the third is in common with the other charges. So what's different about manslaughter in the second degree is that the defendant caused the death of George Floyd by culpable negligence. Culpable negligence, where created an unreasonable risk and consciously took a chance of causing death or great bodily harm. And again, we do not need to prove, the state does not need to prove that he intended to.
Good shit,
that
Anthony.
he intended to kill George Floyd. Culpable negligence, intentional conduct, that the defendant may not have even intended to be harmful, but that an ordinary and prudent, reasonably prudent person would recognize as involving a strong probability of injuries to others. You can look for yourself and you can see exactly what was happening. The bystanders who were at the scene looked for themselves, and it was plain to them. They took video, you saw it, it was plain to you. Strong probability of injury, and with the defendant, his specialized knowledge about the dangers of positional asphyxia and the common sense that if you put your knee on somebody's neck, there's a strong probability of injury, he knew that too. Great bodily harm, bodily injury that creates a high probability of death. Permanent or protracted loss or impairment of the function of a bodily member or organ. The heart, the lungs, the
Good
loss
morning,
of
Claudia.
consciousness. Would an ordinary and reasonably prudent person know that this is dangerous? Everybody who watched knew it was dangerous. A 9-year-old saw that it was dangerous. And the defendant knew exactly what he was doing because he was right on top. He was right on top of him.
Excuse
but
me,
his
guys.
negligence goes
Excuse
beyond.
me. I'm sorry. I have to take a phone call real quick. So please just watch this and stay informed and stay tuned in.
On his intentional assault of Mr. Floyd, his negligence includes his failure to act in your custody means in your care. In your custody means in your care. There is a duty to provide medical assistance. That duty includes not only calling the ambulance for somebody else to do, it means that you have to use your knowledge, your training as a first responder. You're required to perform CPR. It's a requirement. He failed to do it. He had the training. He knew how to do it. You've seen his training records. It's Exhibit 119. You can take a look at all of the in-services, all of the hours. Right? He knew what to do. He just didn't do it. He knew better. He didn't do better. He wouldn't even let Genevieve Hansen, the off-duty firefighter, do it. If he wasn't going to do it himself, he could have let somebody else do it. But he didn't. He had the knowledge, he had the tools, he just ignored it. So when you consider this charge, that the defendant caused George Floyd's death by culpable negligence, where he took an unreasonable risk and consciously took a chance of causing death or great bodily harm, you will find that element has been proved beyond a reasonable doubt, that he is guilty of second-degree manslaughter, guilty of all three charges. So, after all of this, you have another question you have to address. After seeing all of this, finding the assault, finding the murder was committed, the manslaughter was committed, you have another thing to consider, and that is, was this just okay? Was this fine? Is this okay because the defendant was a police officer? Was this an authorized use of force? Was it justified? Was it justified? It was not. Let's look at the instruction of the kind and degree of force a police officer may lawfully use in executing his duties. It's limited by what a reasonable police officer in the same situation would believe to be necessary, and force beyond that is just not reasonable. If you look at the facts that a reasonable police officer in the same situation would have known at the precise moment that the officer acted with force. Right? You're looking at all of the totality of the facts and circumstances to see whether these actions, the defendant's actions, were objectively reasonable. Was this objectively reasonable? No. We just saw the instruction that the law does not provide an excuse for police abuse. It does not. Let's start with the most basic of premises, because that's very important. That restraining George Floyd in this manner,
hell yeah, it's very
on the
important.
ground, prone, handcuff, knee on the neck, knee on the back, body weight on top of him. Start with the premise that that in fact was a use of force. The defense called a witness who actually testified that that was not a use of force because that is not likely to produce pain. No. No.
They had a Klansman
Not
up there,
true.
y'all.
Likely to produce pain,
Allegedly.
actually produced pain. You know, the problem with terms like superhuman strength, you forget that those people don't exist. Humans feel pain. Human beings feel pain. Human beings need to breathe. Don't accept any notion to the...
That was actually said during the fucking trial. If nobody understands or fucking knows about that, that was actually said about George Floyd during this trial by somebody the defense had brought up to testify for them. This man literally said that there was superhuman strength involved. He also said that Derek Chauvin's knee wasn't even on George's neck, and he justified his death all the way through. He said that with a straight face. That's to me, that looks like a Klansman to me.
The contrary. You need to reject that testimony. You need to reject it. And let's discuss the standard. What would a reasonable police officer do? Okay? What would a reasonable police officer do? You don't look at this from George Floyd's perspective. Okay? It's not what a reasonable victim would do. You don't look at it from the bystander's perspective. What would a reasonable bystander do? But under the law, you don't look at it from the defendant's perspective either. You look at it from the perspective of a reasonable officer. And the evidence in this case has shown over and over that the defendant is not that officer, because he did not act as a reasonable officer would. Remember Charles McMillan? Right. Well, the defendant explained his actions. He explained the basis of his actions to Charles McMillan. You recall that. Here's what he said.
Yeah, and I tried to get in the car.
Looks like he's probably on something.
That was his justification for using this level of force. He's a big guy. He's a sizable guy. He might be on something. We have to control him. Control is the restraint. So that's the force. Okay? His two justifications
Bullshit.
were that George Floyd was big.
He was a scary
and that
ass
he
bitch.
might be on something. Well, you know the standards. You've heard the standards many times. You know the difference between a risk and a threat. Officers are authorized to use force to respond to a threat. They're not authorized to use force to respond to a risk. Anybody poses a potential risk. Big, small, in between. Everybody's a risk. Not everybody's a threat. Being large, the act of being large, it's not a crime. It's not a risk. Sorry, it's not a threat. It's merely a risk. Being on something, it's not a threat. It may be a risk, but it's not a threat. And force is not authorized against someone merely because they're on something. And when questioned, their force expert, witness, conceded that the combination of the two, being large and being on something, is not a justification for the use of force.
It's a fact,
It
Khalil.
just isn't. That's not what they get to do. Right? So the defendant's entire basis, his explanation to Charles McMillan at the time, at the scene, right afterwards, after he got up off of Mr. Floyd and tossed him onto that gurney and walked away like it was nothing. That was his explanation. It's not good enough. It's not procedure. It's not the use of force policy. It's not following the rules. Now, we talked a lot about things that might have happened, could have happened, potentials, hypotheticals. Talked about a lot of stuff that didn't happen. Right? You need to focus on what did happen. What did happen. George Floyd
That's
was
what they
not
think,
a threat.
Joe.
He never was. He wasn't resisting. He just wasn't able to comply. They should have recognized that. They should have recognized that. They do it all the time. They had him handcuffed. They had plenty of resources. They had 4 officers. They had a 5th one off in the distance. He was handcuffed behind his back. He wasn't going anywhere. Right? He wasn't doing anything. He didn't need to be put in the prone position. That's a temporary position to facilitate handcuffing. But the defendant was on top of him, stayed on top of him, grinding his knees into him, pressing down on him, continuing to twist his arm, twist his wrist. So it would rip hobble. You've heard about that. They considered using it. They thought about using it. Decided not to. They didn't need to. Right? Because he wasn't doing anything that would warrant it. But if you're going to restrain someone like that completely and holding him down, the policy authorizes the use of the hobble, the rip hobble. Right? They didn't do that. The policy about applying the rip hobble is, again, you have to put the person immediately in the side recovery position. You know, why didn't they do that? The conduct didn't warrant it. They knew it. They didn't want to have to get a sergeant down there to do a force review. It's Memorial Day. Right? You heard that comment. They talked about that.
It's ridiculous.
So they just held him in this dangerous position against policy. A reasonable officer wouldn't do that. A reasonable officer follows the rules. A reasonable officer follows the training. Force that carries a risk of death is deadly force. And you recall the MPD Defense Tactics and Control Guide. Like, deadly force is just not authorized in this situation. No force. When someone is passed out, on the ground, unresponsive. No. You really can't even claim that Mr. Floyd was engaged in passive resistance. At this point, remember Charles McMillan? He kept saying, get up and get in the car. Get up and get in the car. And George Floyd said, I will. I can't. He doesn't even have the opportunity. He's saying he'll get up and get in the car. He isn't given the opportunity to do that. That's not resistance, that's compliance. At least an attempt to comply. Force must be reasonable. It must be reasonable at the point it starts, at the point it ends, and all points in between. Officers are required to reassess the situation, to reevaluate the situation, to take in the information and react to it.
That's a fact. Everybody, J Hurt 21. That's my oldest brother, Jamel. Everybody, shout out J Hurt 21 in the comments, man. Shout out Big Bro, Big Buddha. The prosecution's closing arguments are beginning to become information overload at this point. Mr. Floyd was murdered, case closed, and that's the thing. It seems like it's becoming repetitive, but the thing is, a lot of people out there still don't get it, and we see that. We see it, every day online or wherever the case. Like, there's people that believe that George Floyd really died of a drug overdose, or he died from a heart attack, or he died from now they thinking he died from carbon monoxide. Like, people out there really think that. So let him continue to drive this point into their heads, because for some reason a lot of people don't get it, and he needs the jury to really, really understand the facts of this shit.
The defendant didn't do it. The defense has made the argument that the crowd justified defendant's use of force, like the blame should fall on the bystanders for displaying concern over a man's life. What? But this was a distraction, and there was some concern. The defendant doesn't appear too concerned. It wasn't the bystander's fault. A 19-year police veteran, a field training officer with over 800 hours of training, should not be distracted by the comments of a 17-year-old or being filmed by some civilians. There's a policy about filming. They understand that civilians can film them. They know that. It's right there. This isn't something new or earth-shattering or even particularly noteworthy. Sergeant Steiger, you recall him from LAPD. He used to patrol on Skid Row. He talked about people throwing rocks and bottles. They have a phone. They have phones. They're expressing concern. They're not doing anything. This is not a justification for an assault, for murder. Defense suggested in their cross-examination that reasonable minds can disagree, or that some of the witnesses don't line up exactly where the force began or what exactly should be done, but don't get caught up in that. Don't miss the forest for the trees. Consider the testimony as a whole. Officer after officer after officer got on that stand, raised their hand, and told you, the chief of police, right, that this conduct, the 929, violates the use of force policy, violates the department's core values. He violated his duty of care. He failed to render aid. Remember, Commander, now Inspector Katie Blackwell, who was in charge of all training, looked at this and said, I don't even know what this is. I don't know what this modification is. This isn't how they train. These aren't the rules. Lieutenant Mercel looked at this, and he said, without equivocation, not an MPD trained tactic. It is not. We don't train our people to do this. You can present 1,000 hypothetical situations. You can talk about what didn't happen all day long into next week. But when you talk about what did happen on that day, at that time, That's what they said. Use of force unreasonable. Supervisor, Sergeant Pluger, the force should have ended right after Mr. Floyd was on the ground. His supervisor said that. Lieutenant Zimmerman, the oldest serving, or I should say the most years of service on the Minneapolis Police Department, longest serving,
Call that nigga
correct
old.
myself, longest serving member of the department. What did he say? He looked at this. He said this was totally unnecessary. Totally unnecessary. A use of deadly force. Not reasonable. Only reasonable force is authorized. Sergeant Steiger, expert witness, Los Angeles Police Department. He's trained thousands of police officers. He looked at this. This is objectively unreasonable force. Professor Stoughton, former police officer, University of South Carolina Law School professor. This use of force was unreasonable, it was disproportionate, and it violates national standards. The experts agree. Because the force has to be reasonable when it starts, it has to be reasonable when it ends. And what is happening? If you look at the bottom, George Floyd is handcuffed and on the ground. Right? What is he saying? He's saying, I can't breathe 27 times within the first 4 minutes and 45 seconds of this encounter. He's saying that. And the defendant continues to kneel on his back and neck, continue the dangerous restraint. George Floyd says, into the restraint at 8:22:24, my stomach hurts, my neck hurts, everything hurts. Defendant heard that. He heard those words. Was George Floyd resisting when he was trying to breathe? No.
It was, Khalil.
No. And the defendant heard it, and he acknowledged it, and all he did was mock him. It takes a lot of oxygen to complain. That's what he said. It takes a lot of oxygen to say that. When George Floyd gave his final words to the defendant, please, I can't breathe. I can't breathe, crying out for help by the man in uniform. The defendant stayed right on top of him, ignored it. Continued doing what he was doing, facing the crowd, grinding his knee, twisting his hand. I think he's passing out, Officer Lane says. Officer King can't find a pulse. Now, the greatest skeptic of this case among you, how can you justify the continued force on this man when he has no pulse? No pulse. Continued the restraint, continued grinding and twisting and pushing him down and crushing the very life out of him. It wasn't too late. He could have rolled him over, performed CPR. No, he continued. Past the point of finding a pulse, past the point where the ambulance arrives, past the point where the EMTs get out of the ambulance. What's the goal? What's the plan here? What are we trying to accomplish? This was a counterfeit $20 bill, allegedly. Right? What is going on? Why hold him that long, past that point, past that line that was crossed?
For a fake 20.
Unreasonable.
That's the biggest thing for a fake
force.
20, man.
Unreasonable. Not proportional. Excessive. It violated policy. It violated the law. It violated everything that the Minneapolis Police Department stood for. It was not lawful. I use that phrase, awful but lawful. Right? But force that is not lawful, it's just awful.
Can't spell lawful without awful.
So the defendant is guilty of second-degree murder. He's guilty of third-degree murder. He's guilty of second-degree manslaughter. All of them. Because this was not a justified use of force. You cannot justify this use of force. It's impossible. Not if you apply the rules, not if you apply the standards. that sworn officer to protect and serve. That a sworn officer, that oath that they take. You know,
That's a good question. That's a good question. He said cops carry Narcan with them. If they thought he overdosed, why didn't they hit him with that? Well, let me tell you why. The defense also tried to make the what if argument that when you resuscitate someone who was unconscious, that they become more combative. But the fact that George Floyd didn't even get a chance to be resuscitated, or they didn't do that at all, what would be even the point to even bring that up? But yeah.
At the beginning of my comments, I talked about George Floyd's life, how he was surrounded by people who cared about him, surrounded by familiar faces, people he could look out to in the crowd. That at his death, he was surrounded by strangers. They were strangers, but you can't say they didn't care. You can't say that. These people were randomly chosen from the community. People from the community randomly chosen by fate. And they were coming from different places, and they were going to different places,
Prosecution.
and they
is
had
hitting
different
right now.
purposes. All of them.
That's
Random
crazy.
members of the community. All converged by fate at one single moment in time to witness something. To witness 9 minutes and 29 seconds of shocking abuse of authority. To watch a man die. And there was nothing they could do about it because they were powerless. They were utterly powerless because even they respected the badge. Even seeing this happening, they cried out at first, pointed out, hey, you can get up off him. It became more and more desperate as they watched this go on and on and on, and there was nothing they could do. All they could do was watch and gather what they could. Gather their memories. Gather their thoughts and impressions. Gather those precious recordings. And they gathered those up and they brought them here. And they brought them here and they got up on the stand and they testified and they bore witness to what they saw. They bore witness to this outrageous act. And they told you about it and they gave you what they had. Their thoughts, their impressions, their memories. They gave you those precious recordings so you can see this. You can see this from every single angle. They gave that to you. They were powerless to do anything but that. They gave it to you. Randomly selected people from the community. You got a summons in the mail. And here you are. All converged on one spot. Now, our system, we have power. The power actually belongs to us, the people. And we give it to the government in trust for us to hold and to use appropriately. But sometimes we take it back. Sometimes when something is really important, we reserve those decisions for ourselves. The state, we have power. We cannot convict the defendant. The judge has power, but he cannot convict the defendant. That power belongs to you. You have that power, and only you have the power to convict the defendant of these crimes, and in so doing, declare that this use of force was unreasonable. It was excessive. It was grossly disproportionate. It is not an excuse
Facts.
for the shocking abuse that you saw with your own eyes.
Facts.
And you can believe your own eyes. This case is exactly what you thought when you saw it first, when you saw that video. It is exactly that. You can believe your eyes. It's exactly what you believed. It's exactly what you saw with your eyes. It's exactly what you knew. It's what you felt in your gut. It's what you now know in your heart. This wasn't policing. This was murder. The defendant is guilty of all 3 counts.
Let's go.
All of them.
Let's go.
And there's no excuse.
Let's go.
Thank you.
Let's go. What you got, defense? What you got, defense? When is the defense coming
For
up?
the defense argument before the state's rebuttal and the final instructions.
Hold on. We gotta see when.
Brief break in the trial of Derek Chauvin after millions marched in the name.
So, as you see, that was the prosecution's closing arguments.
Prosecution that
they didn't immediately get to the defense. They need some time to figure out how the fuck they gonna get through this. How the fuck they gonna try to explain their side. This is the one thing that I have been waiting for. It's gonna be a longer show today, a longer stream today. So if y'all stick with me, man, I really appreciate you. If you hit the like, man, hit the subscribe, hit the bell. I would really appreciate it as well. We're going to be here for a minute because the defense still has to go up and say what they need to say. But it's going to be very fucking interesting. It's going to be like a shitty comedy show. Like, there's going to be shitty stand-up that we watch when the defense comes up. Because I don't know how the fuck they're going to get through their closing arguments and what they're going to even say. The prosecution took about an hour and a half, a little bit over an hour and a half for their closing arguments. I don't think the defense has that in them. And if they did, oh my God, would they be bullshitting for a long ass time. Now, we know how far the defense is able to reach. We know the different things that they tried to come up with, you know, even so much so that when all else fails, let's try to say that carbon monoxide played a factor because he was right next to the exhaust. All these different factors, right, that they trying to attribute to George Floyd dying besides the shit that we actually see. Jim Acosta, is that really Jim? They'll wait until tomorrow for a verdict. The jurors want to sleep in their own beds just one more night before going to witness protection. That'd be weird. If that's really, that's really not Jim Acosta, but if it was, that would have been fucking crazy if it really was. I might have to fact check that. I really don't know if that's real. I really don't know if that's Jim Acosta or not, but if they do come up with a verdict by tomorrow, then I have good faith that, you know, it was unanimous because ain't no going back and forth on this. If you are the jury and if you're part of the jury and you just heard the prosecution and everything that they just said, oh man, that it's inevitable the fate of Derek Chauvin, but also the defense has to still come up here and say whatever the fuck it is that they're saying, and I don't know if I can sit through the whole thing just because I know there's going to be that borderline disrespect there, and how they're going to try to use George Floyd as someone who is violent, angry, all that shit. I feel that coming. What's up, 3Gs? What's happening? AP, what's good? This is gonna be it's gonna be a trying time. It's gonna be a test for me because through this entire trial, the defense has gotten under my skin, and I don't know, like, if they're able to get under my skin during some shit where there's continuous objections and continuous pauses and breaks. I can only imagine the type of shit they're going to say sitting up here in front of this fucking stand. What's good, Fooster? What's happening? Big bro. Now, oh my God. It's going to... I just thought about some shit. Tomorrow is 420. I have a big episode tomorrow for 420. I need you all back here tomorrow at 420. It's going to be on 420, which is tomorrow, and at 4:20 p.m. So I'm going to need y'all to be here for that. It's going to be a very exciting show. I'm going to just let you know right now you're going to see some shit that you have not seen happen in front of your eyes before. You probably only seen it on the internet somewhere else. But I'm telling you, we are going to do it right here on the GMS show. You're going to witness history in the making tomorrow. So I need y'all to pull up. I put up a video. If you want to go watch that real quick, I put up a preview of what's going to go down tomorrow. I'll put a little hint of what tomorrow's going to be like. And if you watch that video and you put 2 and 2 together, you'll know that you want to be here to witness that shit. I am not bluffing. I'm not kidding. I'm not playing around. This is going to be some real GMS shit tomorrow for 420. So I need y'all to pull up and really show some love tomorrow for that very special episode. I wonder what they're talking about, actually. I'm not even going to lie.
These families coming together between the Floyds and the Wrights, showing how
they're outside
to
the
them
courthouse
this is
right now.
obviously not a case of one police officer or one man, but a much bigger problem with policing in America. And I've been speaking to many of the protesters out here. There's not too many of them, and it seems that their opinions are split on what they think will happen. Some were very convinced that Derek Chauvin will be acquitted, and a man just said to me that he basically said cops don't get convicted, and he was so convinced that that Chauvin would not be found guilty. But another young man who was much younger than that man said that of course he will. He's been watching the entire trial and cannot imagine what will happen if not. I spoke to another woman who is very afraid, who said she could imagine that he would be found innocent or a mistrial, and that in that case she was afraid what signal that would send to police, that in a case with all this video footage, that if Chauvin could not be found guilty in that case, it terrified her, frankly.
Hannah Jewell reporting live outside the courthouse. Thank you so much, Hannah.
I like how
James,
she put the two. I like how she put the two in between there, like
the relation.
When she made the point. Hold on, let me turn this down.
Really?
She made the point of a older gentleman, making the assumption that he knows that cops don't get off, or cops get off for shit like this. He's not going to be convicted. He's seen it through his lifetime. That's his opinion, and that's something that, you can't even argue with, because we have seen that. It's historic. It's a historic fact that cops get off for shit like this. And then you have a younger gentleman who has watched the entire trial and also feels like how I feel, how if you've watched everything that happened and know everything that happened, there's literally no way possible that they would not convict him on all charges. Like everything that the defense said was bullshit. Everything the defense tried to come up with was a complete reach. Everything was like demonizing of someone who was killed. There's nothing that justified George Floyd dying, and the fact that they reached so hard to try to justify the shit and try to make it seem like that it was something other than a knee to his neck. It's a slap in the face to everything that we have continued to go through in this country. It's ridiculous that we have to continue to face shit like this. And now we in a bigger scale where we're sitting here watching a whole trial from our homes on our phone and on our computers and shit. And now we get to like really watch the blatant disrespect in front of our eyes, especially when it comes to the defense. It's like this is an open and shut case. It don't make no sense why this is like even a debate, why the trial even went this long. It doesn't make any sense that the defense even, I don't even know, man. This whole trial didn't make sense to me, but once again, this is where we live, man.
by other police and even by the EMS that ultimately came to the scene. What did you make of that?
You know, it went along with one of the bystanders who said that she felt that the more that they called out to Chauvin to stop, to check a pulse, to stop and address these symptoms that Floyd was obviously displaying, that he was in distress, she said it felt like Chauvin was becoming enthused by that, for their calls to stop.
He was.
So that's something that Schlescher wanted to point out, that has been in the back of mind of many people who've been watching these proceedings, is what was Derek Chauvin thinking? And did he show this lack of compassion? And Schlescher said that the only thing that he really could have done at that time, that he was trained to do, was to be compassionate. If when somebody said that they can't breathe or said they're claustrophobic and didn't feel comfortable getting in the back of that squad car, show compassion. So that was something, you know, the prosecution may have been doing to show the jury that could have changed everything if Derek Chauvin would have stopped and just showed basic human compassion.
Eugene, you know, as James pointed out, part of that use of the bystanders, part of the prosecution talking about the bystanders, is to have the jury put themselves in their shoes, but also to make them, as James pointed out, less of a threat or less of a danger that Derek Chauvin had to be responding to. So what now is the role of the defense here? How do they have to portray this scene in their closing arguments?
Well, I think what the defense is going to have to do is to try their best to show that Chauvin was in a situation that had gotten out of control, regardless of whether the jury or prosecution thinks that, and that he made the best decisions possible given the situation. That he was not as aware of what he was doing, despite constant claims and yells from the crowd informing him of the pain that Floyd was under, and that he was under threat, and that he felt unsafe, and that he made an action that he believed was in the best interest of the public safety of everyone that was involved. He's going to try his best to humanize Chauvin and try to take away any suggestion that he acted in a way that was maliciously, intentionally harmful, that with the goal of, you know, ultimately leading to Floyd's death.
He wants to.
Well,
did you hear, like, that just sounds fucking stupid, right? That shit sounds fucking stupid, right? There's no way that didn't sound fucking stupid. Like, the defense has to go up there and dehumanize the person who got killed, but humanize the person that killed him. Think about that. There were children and teenagers standing on the fucking sidewalk in control of their fucking body movements. They weren't hostile. They didn't try to rush Derek Chauvin. They didn't try to rush Officer Tao. They didn't try to rush the other two officers. They were trying to fucking plead for a person's life who was already struggling, pleading for his own. And then to try to fucking categorize them as violent, or some people who were like interfering with what the fuck was going on. It's a reach. It's a dumb ass, stupid ass reach, man. It don't make no fucking sense. The prosecution had to remind these motherfuckers that a 9-year-old was there. Like, the defense had to make a 9-year-old look hostile and violent. But of course, he couldn't name the 9-year-old girl or even speak on a 9-year-old girl while talking about a violent crowd, because that would make him look even more stupid. There were children there, man. This is going to be very interesting to see. Like, I as much as I don't want to hear this dumb motherfucker speak, and I know y'all don't want to hear this dumb motherfucker speak, we have to hear the fuckery that comes from this man's mouth. We have to. I have to have this be played out. I don't no, I don't see how this shit is going to help or even convince the jury that George Floyd wasn't murdered. Because that's what they're going to try to, they're going to try to convince the jury that he wasn't murdered, even though everybody watched him get murdered over and over again, day after day, week after week. Everybody had to watch him get murdered over and over again on video during this entire trial. Man, come on now. This is the craziest shit I've ever seen in my life. If it was a cop that got murdered, this trial wouldn't even have lasted a week. I'm just saying. With Chauvin training the other 3 cops, I don't know. All I know is that motherfucker's guilty. And there's no other way to put it.
Is reacting to this trial.
Relatively quiet here in Houston, but the city itself, as George Floyd's hometown, is doing some soul searching in how it's policing and navigating police reform after seeing, like so many other cities, how the world responded to watching George Floyd's death. So there is a new police chief here, Police Chief Troy Finner. He is a sort of change of pace as a local Houstonian. He is from a neighborhood that is not that different from where Floyd is from. Floyd is from historically Black neighborhood, 3rd Ward. New police chief Troy Finner, who is also Black, is from 5th Ward, another historically Black neighborhood here in Houston, and was appointed by the mayor, Mayor Turner, who is from Acres Home, which is another historically Black neighborhood here in Houston, and is the first sort of police chief to kind of climb the ranks, be a native Houstonian, and have been on the force and on patrol, just like the people that he'll be overseeing. So you can kind of see some considerable changes. That's a notable departure for how the department has historically appointed people. Usually they are, they don't necessarily come from the bottom up per se. And so that's something that the city is watching, and communities like 3rd Ward, where George Floyd is from, and 5th Ward, where new police chief Troy Finner is from, are celebrating and observing and acknowledging as a notable shift in response to Floyd's death, and thinking about how to navigate relating to the community and having that kind of relationship that is hands-on and also of the people and representative of the neighborhoods that they are, bound to serve and protect.
Nicole, I know you've been talking to people who went to the same high school as George Floyd. So what do they think about their former high school football star becoming now a rallying cry for racial justice?
To kind of put things into context, Olivia, that's such a great question. 3rd Ward, where George Floyd is from, is actually where I'm from. I walked my dog this morning, and I talked to 2 people who also went to Yates High School and have a sense of optimism after watching and consistently watching the trial every day, and see that sort of shift in how this conversation is happening, how the state is representing, really, as Rhonda is very pro-police, and also kind of acknowledging and bringing in this level of accountability that we haven't seen before. So I'd say generally a community where so many people, every 3rd neighbor per se, either went to Yates High School, had a family member go to Yates High School, be it their child or their parents, or a cousin or sister or brother. There's this immense amount of grief and personal connection to him as someone who not only went to the same high school, but played on a football team that was the epicenter of social life in a neighborhood that has withstood centuries, be it
That's new news to me, Claudia.
Emancipation, civil rights movement, all the way up to today. There's a sense of that could have been me, that could have been my brother, that could have been anyone here. And we heard that earlier when I showed some interviews with the city council representative here, Representative Carolyn Evans Shabazz, who said, that could have happened right in our backyard. And there is a struggle of trying to understand and how to navigate how you talk to young Black people from this community about what happened to George Floyd, and about how you can better protect your life and livelihood, and Representative Shabazz said she didn't have the answers to that and is looking to this trial and to the outcome of this trial to hopefully give voice to trusting police and give voice to having an opportunity to both self-preserve and trust that your best interest is the same best interest of the city, communities, and neighborhoods that she represents, most notably right here in Houston in 3rd Ward, where George Floyd is from. So, while this is Derek Chauvin's trial, it is in many ways something that our country and the world is looking at, and specifically here, 3rd Ward, where George Floyd is from, it says a lot, and it's something that people are looking for the words to try and figure out how to navigate, how to move forward from.
Nicole Ellis reporting for us live in Houston. Thank you so much, Nicole. Let's turn now to Mary Beth Albright, who's watching the legal aspects of this case. So, Mary Beth, the prosecution went through in great detail, sort of a nice chart that they had made to show the jurors, look, if you find this and this and this, then you got to find him guilty, right? If you hit these qualifications, A, B, C, D, you got to find him guilty of this charge. I think the judge is coming back now, so we'll go to you later in one of our other breaks as we hear the defense
let's go.
In this trial.
You ugly fucking smug fucking piece of fucking shit, bastard bitch.
Counsel.
You look like a fucking. You look.
Chauvin.
Derek Chauvin looked like he fucking put his finger in his ass.
I want to take this
smell
opportunity
it on a
first to thank each and every one of you for your service, your diligence, and your attention to this matter. We all recognize the disruption that jury service places on your personal and professional lives, especially in a case of this magnitude and duration. And so on behalf of Mr. Chauvin, I want to thank each and every one of you for your attention and service to this jury. I'm going to apologize if I get a little long-winded, because I get one bite at the apple here. The state has an opportunity to rebut my statement after this. There's so very much we need to cover. There's so very much we need to talk about, and it is all important.
Really, is it? What important things do you have to say?
Before I begin my review of the evidence in this case, I would like to address two very crucial points of law, and they were touched on by the state. The presumption of innocence and what proof beyond a reasonable doubt means. The presumption of innocence, the defendant is presumed innocent. That's the starting point. He's presumed innocent of these charges. And this presumption remains
they always start with some bullshit.
Throughout the course of the trial, the presentation of the evidence, throughout the course of your deliberations, until and unless the state has proved its case beyond a reasonable doubt. The defendant does not have to prove his innocence. We talked about this in jury selection. We talked about the starting point. The defendant doesn't have to try to catch up. He starts at the presumption of innocence. Proof beyond a reasonable doubt. Here's the definition that the judge just read you. Proof beyond a reasonable doubt is such proof as ordinary prudent men and women would act upon in their most important affairs. A reasonable doubt is a doubt that is based upon reason and common sense. It does not mean a fanciful or capricious doubt, nor does it mean beyond all possibility of doubt. The law recognizes...
Who you know got a permanent frown like that? But somebody who is fucking evil. Think about that. Really think about that. This nigga has a permanent frown. Every time you see him, he has a permanent frown. This is a fucking evil motherfucker. I bet when he smiled, his lips still stay down. His upper lip just kind of moves up a little bit. Like, this is amazing.
Standards of proof. The preponderance of the evidence is the first and lowest standard. Clear and convincing evidence is the next standard. And the third standard is proof beyond a reasonable doubt. And the way we lawyers sometimes illustrate what these three standards mean is through the scales of justice, right? The scales of justice equally balanced. When you apply the standard of the preponderance of the evidence, it's also called the scintilla of the evidence. A single grain of sand tips the scales in the favor of one party or the other. And this burden of proof is used in many civil cases. If the state wants to take away your driver's license, for an example, that is the burden of proof that the state has in that type of a case. They have to just ever so slightly convince the finder of fact that their evidence supports their action. The next standard is clear and convincing evidence. I mean, that's pretty self-explanatory, right? It is clear evidence, and it convinces you, the finder of fact, that the action is correct. This is the standard of proof that is used if the state wants to take away your children. Clear and convincing evidence.
Nigga talking about some bullshit.
It tips the scales more in the favor of...
All they've done is dealt with fucking hypotheticals and what ifs and all this other extra shit that has nothing to do with the fucking case at hand. Prosecution went up there and talked for an hour and a half about just the fucking murder and what happened to George Floyd. This nigga talking about the state taking away your babies. The fuck, this is what I mean. If the jury don't see through this shit, goddamn.
One party over the other. The highest standard in this country is proof beyond a reasonable doubt. Proof beyond a reasonable doubt. Essentially, what the state has to convince you is that the evidence in this case completely eliminates any reasonable doubt, or in other words, leaving only unreasonable doubt. Capricious, fanciful. Capricious doubt, capricious means unpredictable. Fanciful, space aliens flew in, inhabited the body of Derek Chauvin, and caused this death.
Listen to
That's
this.
fanciful.
What the fuck are you talking about?
Beyond the reasonable doubt. It is the highest standard in the law. Doesn't mean beyond all possibility of doubt, because I suppose space aliens may have been inhabiting his body, but that's obviously fanciful and capricious.
I'm convinced he's on our side, because
So
there's no way he could be this fucking stupid.
The presumption of
expect to win
innocence
this case.
and proof beyond a reasonable doubt work in concert with each other. You start with the proposition that Mr. Chauvin is innocent of these charges. The state has to advance substantial evidence to convince you that the only doubts that are remaining are unreasonable doubts.
This is ridiculous. This is stupid as fuck. I already knew I was going to get irritated as hell.
As you analyze the evidence in this case, you would simply have to find that any defense that has been advanced is unreasonable. That's what this standard is all about. I want to take this opportunity also to talk to you about the importance of reading the entire instruction. Because I've seen, and lawyers, and I'm going to do it too, right? We pick and choose those things that help us make our case and help us argue our case. That's our job as lawyers, is to point out words and phrases within the instructions that make the difference in the case, and to take that evidence and present it to you in such a way that it supports our proposition. That's what we do. That's why you are instructed that if your memories of the evidence is different, that if the judge's law is what applies. But take the time to carefully read the entire instructions.
Oh, man.
throughout the course of this trial, you've seen us do this, right? Little snippets. A second here, a second there, a screenshot here, a screenshot there. You need to review the entirety of the evidence in this case during the course of your deliberations as well. And I can tell you that some of the videos that we've seen, they're much longer than what was presented in court. There's additional information, and you're going to see some of that as we go through this case today. So take the time and conduct an honest assessment of the facts of this case, compare it to the law as the judge instructs you, and the entirety of the law. That's why the instructions tell you, consider the instructions as a whole. I've told you that lawyers like to present evidence that favors them, right? But we have to be intellectually honest about the evidence. We have to present it in an honest and intellectually cohesive and coherent manner. And I have to address something that I think is important. And I think it is a prime example of what I am asking you and what is your obligation to do to look at the evidence in light of all of the other pieces of evidence, right? So you heard during the testimony of Dr. Fowler that one of the things that he considered is the possibility that carbon monoxide was present and could have contributed to an environment that created an oxygen deprivation.
The what ifs. Shut the fuck up, man.
You heard that testimony. In rebuttal to that testimony, the state brought Dr. Tobin back in, and he told you we can completely disregard that. We know as a fact, we know conclusively that Mr. Floyd did not have carbon monoxide because his oxygen was saturated to 98%. And you just heard the state say, just like I am right here, right? So it stands to reason. I could get up in front of you and I could argue to you, we know this wasn't asphyxiation because George Floyd had a 98% oxygen level. How could he have been asphyxiated at the hospital with a 98% oxygen level? But that's not intellectually honest. It doesn't stack up against the rest of the evidence because of what we know, right? We heard the testimony of Seth Bravender.
He tried it.
And Derek Smith, the paramedics.
He tried it.
We heard the testimony of Dr. Langenfeld. They came in and they said they began resuscitative efforts. They introduced oxygen, an oxygen supply. They're manually breathing for him. They're reoxygenating his blood. So when you look at that piece of evidence, when you look at a piece of evidence like that, you have to compare it against all of the other evidence.
Do you?
Because you can't come in and say, George Floyd, on one hand, George Floyd died of asphyxiation, but he has a 98% oxygen level, right? His blood is oxygenated. Then it stands to reason the opposite is true as well. You can't come in and say, I can conclusively prove that Mr. Floyd didn't have carbon monoxide in his blood because he had this high oxygen saturation. You test one statement against the evidence of other people and you compare it. That is what you as jurors are obligated to do and what I am asking you to do. Compare the evidence against itself. Test it. Challenge it. Compare it to the law. Read the instructions
what happened to
in
the drugs?
their entirety. Start from the point of the presumption
what happened to the
of
drug
innocence
overdose?
And see how far the state can get.
You would have thought they would have started with
that. That the state has failed to meet its burden of proof beyond a reasonable doubt.
Come on, man.
Mr. Chauvin has been charged, as the state indicated, with these 3 charges, and the judge has instructed you. Count 1 is second-degree murder while committing a felony. It's also called the felony murder rule in Minnesota. Kind of the textbook example is, I run into a liquor store, I pull a gun, I'm intending to rob the liquor store. My gun goes off, I shoot and kill the teller. I didn't intend to go in and murder that person, but the death of that teller occurred while I was committing a felony. That's the felony murder rule. He's been charged with murder in the 3rd degree for performing an intentional act that is eminently dangerous. Right? You've seen the instructions, you've heard them. And manslaughter in the 2nd degree. Again, the law has all of the words, it defines the words you need, and the instructions should be considered in their entirety. Whenever I meet with a client, I try to explain what the elements are, and this is the analogy that I use. I say,
you gotta lie.
A criminal case is kind of like baking chocolate chip cookies. You have to have the necessary ingredients. You've got to have flour and sugar and butter and chocolate chips and whatever else goes into those chocolate chip cookies. If you have all of the ingredients,
now you're talking about chocolate
you
chip
can make
cookies.
chocolate chip cookies.
It's over
but if
for
you're
Chauvin.
missing
It's over
any
for this
one
nigga,
single
bro.
ingredient, you can't make chocolate chip cookies. It's a simple kind of analogy. But the criminal law works the same way. We say we call the ingredients the elements. The state has the burden of proving each and every element beyond a reasonable doubt. Not just some global proposition that they've proved their case beyond a reasonable doubt.
Y'all clowning
They have to prove each of these elements beyond a reasonable doubt. And if you determine that they have done so, you convict. But if they are missing any one single element, it is a not guilty verdict.
We went from aliens to cookies. What are we going to talk about next, defense?
And you saw the spreadsheet that the state put up.
What are we going to talk about next?
Elements are a little different in each
fuck
of
this
these
guy.
cases. And some of these elements will take less of your consideration.
Jesus.
You will have to look at the evidence, and you will have to, for example, determine is Cup Foods in the city of Minneapolis, is Minneapolis in the county of Hennepin, is Hennepin County in the state of Minnesota? Did this happen on May 25th, 2020? Right? It's going to take less of your consideration, but nevertheless, you have to do that. You have to go through that process.
He's prosecuting right now.
2 of the elements that I want to focus on during the course of my discussion here today, 2 of these elements are common throughout, or 2 of these issues are common and apply to all 3 counts. And so I want to focus my remarks today on those 2 issues. The first, were Mr. Chauvin's actions an authorized use of force by a peace officer? Right? Because in the instructions, it specifically tells you no crime is committed if it was an authorized use of force. Period. End of discussion.
It's a milk and cookie.
The second is an element that is and does appear in all 3 counts. That is the cause of death. What caused Mr. Floyd's death? And we're going to talk about that second. So, let's start with the concept of reasonable force. As the instructions read in their entirety, no crime is committed if a police officer's actions were justified by the police officer's use of reasonable force in the line of duty in effecting a lawful arrest or preventing an escape from custody. The kind and degree of force a police officer may lawfully use in executing his duties is limited by what a reasonable police officer in the same situation would believe to be necessary. Any use of force beyond that is not reasonable. To determine if the actions of the police officer were reasonable, you must look at those facts which a reasonable officer in the same situation would have known at the precise moment the officer acted with force. You must decide whether the officer's actions were objectively reasonable in light of the totality of the facts and circumstances confronting the officer and without regard to the officer's own subjective state of mind, intention, or motivations. The defendant is not guilty of a crime if he used force as authorized by law, and to prove guilt, the state must further prove beyond a reasonable doubt that the defendant's use of force was not authorized by law.
Now refer back to the aliens and the cookies that I was talking about earlier.
You remember from my opening statements and how I talked about reason and common sense.
See?
The reasonable police officer standard.
I called it. I knew who he was going to say next.
Just briefly add one thing here.
I could be a public
defender. The standard
defender.
is not what should the officer have done in these circumstances. It's not what could the officer have done differently in these
now you're talking about what ifs and how they're bad. You're talking about what ifs now?
What were the facts that were known to this officer at the precise moment he used force, and considering all of the totality of circumstances and facts known to the officer, what would a reasonable police officer have done? You have heard from numerous experts, police use of force experts, the training department from the Minneapolis Police Department. You've heard from police officers, street police officers, Sergeant Edwards, Sergeant Pluger, right? So you've heard from these people, and they have given you their opinions at various stages as to the reasonableness of the use of force. But one of the things that one of the things that all of these police officers effectively agreed to is that when you look at the question of what would a reasonable police officer do, knowing the facts of the case, there are things that a police officer is entitled to take into consideration above and beyond the facts, right?
Chauvin made sure he had on that blue for trial.
They receive. Their experience as a police officer, the department's policies on the use of force. And all of these things kind of lead into the question of, most critically, what are the facts that were known to the police officer, the reasonable police officer, at the precise moment the force was used? So you can start at a very high level, right? What were the reasonable police officer's knowledge of the area be? Is this a high crime location? Is it a low crime area?
God.
Those are things, those are facts that a police officer would know. What are the specifics
demonizing
of the
hood.
location of arrest, right? Am I going into a densely populated urban environment, or am I in a kind of a secluded backyard, right? Officer is calculating these pieces of information and assessing the risk, assessing the threats. Officers are entitled to kind of take into consideration things that you and I don't think about. Their tactical advantages, their tactical disadvantages. They can take into consideration the scene security, keeping the scene secure, and security of the scene, right? Those are two different concepts. So kind of, again, focusing back into what facts were known at the precise moment force is used, you can then take into consideration kind of this mid-range level of information. A reasonable officer wants to keep his fellow officers safe. A reasonable police officer takes into consideration the safety of civilians. The reasonable police officer takes into account the safety of the person that they are arresting. They take into account, what resources do I have based upon how close am I to a hospital? What's the expected time if I call EMS? Because a reasonable police officer at times, they got to put the person in their squad car sometimes and take them because they're farther away calling for help, bringing help in, would take longer than it would simply to take the person directly. And then you look at the direct knowledge that a reasonable police officer would have at the precise moment force was used. That includes information that they gather from dispatch, their direct observations of the scene, the subjects, and the current surroundings.
Facts, Khalil.
They have to take into consideration whether the suspect was under the influence of a controlled substance. They can take into consideration, because again, this is a dynamic and ever-changing, just like life. Things change. It's a dynamic situation. It's fluid. They take into account their experience with the subject at the beginning, the middle, the end. A reasonable police officer tries to predict or is at least cognizant and concerned about future behavior based upon past behavior. But the unpredictability of humans factors into the reasonable police officer's analysis too. Because sometimes reasonable police officers take someone into custody with no problem, and suddenly they become a problem. It can change in an instant. A reasonable police officer will take into consideration his immediate surroundings. Are there bystanders? Are there civilians? A reasonable police officer will take into consideration who he is at the scene with. Are these veteran officers? Are they rookie officers? What do I know about my partners and my partner's abilities? So throughout the course of this trial, the state has focused your attention on 9 minutes and 29 seconds. The proper analysis is to take those 9 minutes and 29 seconds and put it into the context of the totality of the circumstances that a reasonable police officer would know. And the proper analysis starts with, what did the officers, or what would a reasonable officer know at the time of dispatch? Well, these are records that are kept. They've been introduced. You can look at them. This is Exhibit 151. This is the computer of the dispatch. You heard the testimony of Jenna Scrooge. This is information.
That's how I feel right now.
Passing out to the
That's how I
officers.
feel right now. I don't want to listen to this nigga right now. I don't.
You'll see that the initial.
That's why I got the Wakanda colors up right now. I'm not fucking with this guy right
police officer
here.
has in his squad car, looking at his computer or hearing over the radio, was that on May 25th, 2020, at 20:02:13, so that's 8:02:13, a business, Cup Foods, who police officers have the obligation to respond to these calls, whether it be from a person or a business. But a citizen of the state of Minnesota, Minneapolis, runs a business, and they called for assistance. And they told the officers, the reporting party, there is a male who provided a counterfeit bill to the business. He's 6 feet tall or higher.
Your Highness, the new king.
He's sitting on top of a blue Mercedes ML320 SUV. The license plate also appears this subject is under the influence. So the analysis of what a reasonable police officer would know in this circumstance is that a business is requesting its help. The suspect is still there. He's large, and he's possibly under the influence of alcohol or something else. So the analysis begins at 8:02 and 13 seconds. You may recall the testimony of Jenna Scurry as well, and it's not reflected in this exhibit pretty well, but in the evidence, exhibit number 10, you can hear the audio recording of the dispatch, Jenna Scurry to the officers. Jenna Scurry informed you that initially Officer Chauvin was assigned to this call on a Code 3 Priority 1 basis. It's Code 3, get there lights and sirens, get there fast, right? It's Priority 1 because the suspect is still on scene. So per the Minneapolis Police Department policy, get there fast, the person is on scene, right? That's what she testified. And then very quickly after that, that occurred at 8:04 and 28 seconds. Then what you see is what she told you, was that the sector car 320, that's the car that patrols this part of the city, said, hey, we can take this call, and Officer Chauvin and Officer Tao were canceled from the call. Right? So they were canceled from the call. And sector car 320, Officers King and Lane took it, and that occurred at 8:05 and 11 seconds. When Officer King and Lane took it over, you can hear, again, you can go back and you can listen to that audio of that dispatch, and you can hear them talking to each other. Officers King and Lane arrive at the Cup Foods at 8:08 and 20 seconds. So now we see police officers are responding. They're on scene at 8:08. Both Jenna Scurry and Peter Chang described that during the course of the interaction between the initial interaction between Officers King and Lane and Mr. Floyd, through dispatch they heard what sounded like the sounds of a struggle. Jenna Scurry described she's trained to listen. She heard these sounds of a struggle, and she aired out on her own, other officers need to respond, Code 3, to assist Officers King and Lane, right? So a reasonable police officer, he's going emergent to a scene, he gets canceled from the scene, he's now being told that other officers need assistance, and step it up, get there fast. So you can see, again, based on the records, that at 8:10:08, 20:10:08, backed up 320 with 330, right? So now 330 is Officer Chauvin and Tao. They're backing up Officer King and Lane.
No, it is a joke.
And you can see Peter Chang.
I said it before they came up. This is going to be like the worst stand-up special you've ever seen in your life. You hear this motherfucker is completely Amy Schumering this fucking trial.
So that means they're removing someone from the vehicle at 8:11:02. The scene is ultimately C4, Code 4, all clear at 20:12:21. So literally this demonstrates to you a couple of things. How quickly a situation can change from second to second, minute to minute. They went from get there fast, back off. Get there faster because someone needs help. It's clear. The situation is dynamic and it's fluid. They're provided with information that an officer needs assistance. They testified about the sound of a struggle, right?
That we saw on video.
And if you recall, Sergeant Steiger specifically said all of this information would be known to a reasonable police officer. And it goes into and factors into the reasonableness of the use of force. Ultimately, Officer Chauvin and Officer Tao arrive at Cup Foods. Just pause this for 1 second here. Sorry.
Yeah. Get your shit together. Get your shit together.
To give you
fucking
a
clown
piece of information. When we look at Officer Chang's video, Officer Chang arrives first. You see the time is 1:16:33 Z Zulu. That's Greenwich Mean Time. Subtract 5 from 1 a.m., get you back to 8. So,
let me just make sure I have this queued the fuck up, just in case, you know. Just in case.
Officer Chauvin and Officer Lane.
I feel some bullshit coming, you know.
8:16. Go over there.
Okay, just stay put, all right? I don't want anybody
Defense
near
like
his car.
James Harden.
Information gathering in terms of this assessment and reassessment of, again, the decision-making process of a police officer.
Stuttering
right?
ass.
Don't come over here where I am, Officer Chang says.
Sir.
Go over there. They need your help. Because what at that point, at that precise moment, they don't know what's happening over at the squad car. They don't know that Officers King and Lane struggled with Mr. Floyd, getting him out of the car, that they sat him down, that they stood him up, that they walked over. They haven't seen any of this information, and there's no evidence to suggest that they had. So that doesn't factor into the information. It's, again, a reasonable police officer. What do they know? And they don't know that. But they're starting to get some indication, hey, go over there, right? Go over there.
He sucks, man. This guy fucking sucks.
You can see right at about 8:17, and I apologize for the quality of the picture, Officer Chauvin is arriving and walking up to the squad car. So what would a reasonable police officer see in this instance? What a reasonable police officer would see could be defined, because again, a reasonable police officer has to be aware of his department policies. Active aggression.
He said, ooh, somebody seems like a struggle. Let me fucking abuse my authority. This is my chance. When somebody is struggling or when it seems like somebody's resisting, this is my chance to do what the fuck I want to do to them and excuse every action. That's what that is.
Or active resistance. Let's call it active resistance. A response to police efforts to bring a person into custody or control for detainment or arrest. A subject engages in active resistance when engaging in physical actions or verbal behavior reflecting an intention to make it more difficult for officers to achieve actual physical control. So as Derek Chauvin walks up to this scene, he has all of the information from dispatch. He has all of the information from Officer Chang sending him over. He knows his department policy on the difference between active aggression, active resistance, passive resistance, based on policy, training, etc. This is an officer's consideration of, again, the use of force. All of these things factor into it. So what does he see? He sees Officers King and Officer Lane struggling with Mr. Floyd, attempting to put him into the car. He hears the words that Mr. Floyd is saying at that point. I'm claustrophobic. I'm a good guy. I'm a good man. I'm claustrophobic. I just had COVID, right? He's hearing this information. He's observing with his eyes. A reasonable police officer is observing this with his eyes and his ears and assessing what he sees pursuant to policy. And what he sees.
Somebody said, all I got to say about this trial is Chauvin got the defense team he deserved.
At a minimum,
that is a fucking fact.
Mr. Floyd's not just
shout out to
getting
Minnesota,
in the
man.
backseat of the car. So let's watch. What does Officer Chauvin see when he walks up? This is from his body camera from 8:17 and 21 seconds to 8:18 and 15 seconds. Just shy of a minute.
You can't win. I'm not trying to win. Go and get in the car. I get on the ground. Anything. Go and get in the car. He know it. He know it too, Mr. Officer. Y'all hear me? Don't do me like that, man. Please. Okay, can I talk to you, please?
So you get in this car. We can talk.
I am claustrophobic.
I'm hearing you, but you're not working with me.
God, I'm claustrophobic right there, man.
Get in the car.
Get in the front. Please.
No, you're not going to
I'm claustrophobic.
Get in the car.
Okay. I'm not a bad
He even said put me in the front. Even though that's not legal, like he wasn't.
Please. Hold on a minute. No. You take the seat. Hold on a minute. I can't choke. I can't breathe. Please. My wrist, man. Please. I can't take that, man.
By 8:18 and 15 seconds, Officer Chauvin has not laid a finger on Mr. Floyd, but he's observing, and a reasonable police officer is doing this. He walks onto a scene, he sees active resistance occurring, potentially active aggression occurring. He has two other officers. He has not intervened. But again, based on the policies and the training that you have seen, what were his options available to him at that time? If a person is actively resisting in the center, distraction techniques, controlled takedowns, conscious neck restraints. Can you clear that in? Right. These are options available to Mr. Chauvin at this point. He has, per his training, these techniques at his disposal. A reasonable police officer would be making these observations. He would observe the white foam around Mr. Floyd's mouth. He would consider the possibility that this person was under the influence of something. Basically, using the information from dispatch, making these observations, how is he analyzing this? How would a reasonable officer analyze this, and what would be known to a reasonable officer? A reasonable officer would look at the size of the person and assess that person's size in relation to his own size, because it's a part of the risk-threat analysis, right, that we've heard about so much. A reasonable officer would know that these are two rookies putting this man in the car. In fact, as the evidence established, Mr. Chauvin trained one of the officers. So a reasonable officer may step back at this point to see if these two guys can get this under control. A reasonable officer will hear the words that the suspect is saying. I'm a good guy, I'm a good guy, I'm a good guy, I'm claustrophobic. And he's going to compare those words to the actions of the individual, right? Because this is part of the analysis. Because I can say, I'm going to cooperate with you, I'm going to do whatever I want. But if my behavior is inconsistent with what I am saying, a reasonable officer takes that into consideration. In fact, a reasonable officer who's aware of his department policies knows the de-escalation policy that is in place. And part of what a reasonable officer has to do is to consider whether a subject's lack of compliance is a deliberate attempt to resist or an inability to comply based on these factors. Medical conditions, mental impairment, developmental disability, physical language barrier, influence of drugs or alcohol, or behavioral crisis. So a reasonable officer has to take the information and assess, is this suspect purposefully or intentionally, deliberately trying to thwart our efforts to take him into custody, or are they experiencing one of these other types of factors? But such consideration, when time and circumstances reasonably permit, shall then be balanced against the incident facts when deciding which tactical options are the most appropriate to resolve the situation safely. So again, reasonable officer, based on the totality of these circumstances, is going to take all of this information in, all of these policies, all of these training ins, and a reasonable officer at that point would conclude that the amount of force that was being used by officers King and Lane was insufficient. It was not enough use of force to overpower Mr. Floyd's resistance to getting into the car. He's seen it, he's heard it, he's familiar with the policies, and so at precisely 8:18 and 15 seconds, Officer Chauvin goes hands-on. Officer King, Officer Lane, and Officer Chauvin struggled, fought, whatever adjective you want to use. They struggled with Mr. Floyd.
He made sure he said fought, even though he knows that's not the truth.
8:19 and 12 seconds. About a minute, a little over a minute. It doesn't really seem that it's that long of a time, but again,
it's not.
The amount of physical exertion. Remember how Sergeant Jody Steiger described this. When the apparent attempts to get him into custody were futile. I wrote his quote down. The futility of their efforts became apparent. They weren't able to get him into the car. 3 Minneapolis police officers were not able to get Mr. Floyd into the car.
1. I'm sorry, I have to correct that. 1 officer tried to get him in the car. When he put him in there, George pushed himself out into another officer who he just tried to explain didn't even touch George. And then that's when he intervened and got George out of the car and put him down face down. Think about that. This motherfucker has been trying to manipulate this case since fucking day one.
They themselves are experiencing that surge of adrenaline. A reasonable police officer will be experiencing that surge of adrenaline.
It's cold in here. I need my blanket, nigga.
And again, balancing all of the evidence against each other, right? Let's look at 3 different angles of this struggle. This is Officer King's body camera.
The struggle.
I'm going down. I'm going down. I'm going down.
Get in the squad.
I'm going down. I'm going down. I'm not going to leave you. Bro, you won't die a heart attack. I know, can you breathe? Get in the car. I can't go get man. I can't breathe.
Take a seat.
Please, man. Please listen to me.
Is he going to jail?
Listen to me.
He's under arrest right now for forgery.
I tell you.
Can we figure out what's going on?
Forgery for what?
Let's take him out.
For what? Please, man. I can't fucking breathe.
Hey, come on out.
Look at you. Thank you. Thank you.
Get him down on the ground. Yeah, on the ground. On the ground.
My visa.
He's under arrest for forgery. Forgery for what? This is the video of the same time period from Officer Lane.
I'm on the ground. I'm on the ground. I'm on the ground.
Get in the squad.
I'm on the ground. I'm on the ground. I'm going down. I'm going down. I'm going down.
Get in the squad.
I'm going down. I'm going down. I'm not going to breathe. Bro, you look down a heart attack shit, man. Get in the car. I know I can't breathe. I can't breathe. I just told me, man. I can't breathe. I can't breathe. Please, man. Please listen to me.
Is he going to jail?
Listen to me.
He's under arrest right now for forgery.
I tell you.
Can we figure out what's going on?
This motherfucker checked his wedding ring.
Please, man. I can't fucking breathe.
Hey, come on up.
Look at you. Thank you. Thank you.
Yeah, just when you get up on the ground. I appreciate that.
Officer Tao.
Man, I'm down the ground. I'm down the ground. I'm down the ground.
Handcuffed. That's why I'm not saying shit, because the video is showing him handcuffed.
I'm going down. I'm going down. I'm not going to run, man. Right. I know I can't breathe. I can't breathe.
You're talking and oxygen. Not breathe.
I just had COVID, man. I can't breathe. I can't.
He's under arrest right now for forgery. I don't know what's going on.
Forgery for what?
Let's take him out.
For what? Please, man. I can't fucking breathe.
Here, come on out.
Look at you. Thank you. Thank you.
Yeah, just
on the ground.
I appreciate that.
Keep playing it.
A reasonable police officer understands the intensity of the struggle. You can see at points when Mr. Floyd's legs kick back, it actually almost knocks Officer Lane.
Oh, get the fuck out of here.
It knocks off the body-worn camera and the badge of Officer Chauvin in this struggle. A reasonable police officer would understand this situation, that Mr. Floyd was able to overcome the efforts of 3 police officers while handcuffed with his legs and his body strength. A reasonable police officer standard can be seen in another way, from the milestone camera. And this is what caught the attention of the 911 dispatcher, Jenna Scurry. She said she observed the struggle and the vehicle rocking back and forth, back and forth. Watch the vehicle.
Why are we watching the vehicle from a fucking street cam when you have body cam footage? It doesn't matter. Show what the struggle is. Why are we even watching this camera? What the fuck is the point of this when there's body-worn camera that we just watched of why the car was shaking? This nigga was handcuffed. He was handcuffed. Yelling that he was claustrophobic and he couldn't breathe. He didn't want to be in the car. Talking about the fucking car shaking. Why are we looking at a street camera? You just showed all body cam worn footage from every officer in that motherfucker. Why are we watching this now? Every possible way to try to justify George Floyd being some type of violent ass monster who was just some big superhuman that they couldn't control. Y'all brought the weakest, most cowardice, punk ass cops to come deal with a fucking counterfeit 20, an alleged counterfeit 20. Dumbass defense. Y'all keep playing the video of how he got killed, and y'all think it's justifying the fact that Derek Chauvin wasn't the reason. Like, keep playing the video. Keep showing the jury that their conviction of Derek Chauvin is very, very precise, very, very on point. Yeah, because we look like, see, so one man in handcuffs is a danger to 3 race soldiers. I'm confused. Yeah, that's how much they fear us. That's how much of a fucking threat we are to them.
Reasonable police officers will consider their training, right? And before we talk about the training again, there's something that I think is really important to understand. 2 things, actually, at this moment.
What is it?
Not a single use of force expert that testified, not a single police officer who testified said that anything up until this point was unlawful or unreasonable. It was reasonable for these officers to put them into Mr. Floyd into the squad car. It was reasonable. The efforts that they took to overcome his resistance were reasonable. Every single expert agrees that to this point, nothing is contrary to policy, training, defensive tactics, crisis intervention, all reasonable. It's at the point that Mr. Floyd is brought to the ground that there becomes dispute about the reasonableness of the use of force and what a reasonable officer would know.
No, I don't think they ever presented
It was
that.
Seth Stoughton, the law professor, who said at the point Mr. Floyd came out of the car, putting him on the ground was unreasonable. So, was it reasonable for Officer Chauvin or a reasonable police officer to put Mr. Floyd on the ground in that instant? So a reasonable police officer is going to rely on his training and information, his evidence, what he knows, all of the information he's built up to this point. You heard Lieutenant Mercel testify about how about 15 years ago the Minneapolis Police Department went to ground defense tactics, getting people on the ground to control them, control the head, control the body. Different types of moves that the police use to create and eliminate space. Escape versus control. Those are two different things. These are the tactics that have been employed by the Minneapolis Police Department for 15 years. Why? Because it's safer for the officers and it's safer for the suspects. It keeps people contained, controlled, and confined until they no longer are resisting.
The prosecution blew this motherfucker out the water.
A reasonable police officer would also consider his department's policies, including the use of non-deadly force policy. Force that does not have the reasonable likelihood of causing or creating a substantial risk of death or great bodily harm. This includes, but is not limited to, physically subduing, controlling, capturing, restraining, or physically managing a person. This is the policy, 5-302 of the Minneapolis Police Department, that non-deadly force can be used to physically manage a person.
Except kneeling on someone's neck is deadly force,
again,
you stupid motherfucker. Hold the fuck up. Hold up. I'm sorry.
To this point,
the new king
reasonable,
is
lawful,
the new king.
And so we get into the 9 minutes and 29 seconds at this point.
I don't want to hear it.
The state has really focused on the 9 minutes and 29
goofy
seconds.
ass looking motherfucker, man.
9 minutes, 29 seconds. 9 minutes, 29 seconds. It's not the proper analysis because the 9 minutes and 29 seconds ignores the previous 16 minutes and 59 seconds.
No, it doesn't.
It completely
right,
disregards it.
I'm going to shut the fuck up.
It says, in that moment, at that point, nothing else that happened before should be taken into consideration by a reasonable police officer. It tries to reframe the issue of what a reasonable police officer would do.
Yeah, we need police reform.
A reasonable police officer would, in fact, take into consideration the previous 16 minutes and 59 seconds. Their experience with the subject, the struggle that they had, the comparison of the words to actions, it all comes into play. Why? Because human behavior is unpredictable. Human behavior is unpredictable, and nobody knows it better than a police officer. Someone can be compliant 1 second and fighting the next. Someone can be fighting and then compliant. Nobody knows it better. But reasonable police officers continue to assess and reevaluate. This is the critical decision-making policy, right, or model. You gather information, you assess the threat versus the risk. Do we have an authority to act? What are our goals and actions? Review and assess. Start over. Because this is not a singular cycle. This is a cycle that humans, as humans, we literally make millions of decisions in a day, right? Do I go this way? Do I go that way? Do I go up? Do I go down? I mean, we are constantly doing this. This is just human behavior. But in the policing context, you have to gather the information, assess the risk, assess the threat. Do I have authority to act? What are my goals and actions? Review and assess. And it's constantly rotating.
This guy's dumb as fuck.
Precise moment that Mr. Floyd was laid on the ground, a reasonable police officer would know about those previous 17 minutes. A reasonable police officer would know about the struggle. A reasonable police officer would consider the suspect's reactions to the previous use of force. A reasonable police officer would continue this process of reassessment. And a reasonable police officer would consider whether to use an additional force to overcome the suspect's level of resistance, right? So 9 minutes and 29 seconds.
I appreciate that. I do. You got your hobble? Jesus Christ. Thank you. That movement.
Mama. Continuing to assess the risk and the threat. The first 29 seconds, 20 seconds, continued resistance is what a reasonable police officer would interpret that to be. Jesus Christ, the kicking. A reasonable police officer would consider, should we elevate the use of force as we meet this threat? And that's precisely what these officers did. They discussed using the MRT, the hobble.
Oh, please, man. There you go. And doing a lot of
Mama, I love you.
Are we calling for
I
EMS?
can't do nothing.
Yeah, EMS is on their way.
My face is gone.
Well, do you want to hobble at this point then?
I can't breathe, man.
I fucking hate listening to this shit, dude.
Understand. No, please, man, I can't breathe.
They're discussing, should we use the hobble? Should we elevate our use of force? A reasonable officer would continue to evaluate whether the suspect is under the influence. Precisely what these officers did in 9 minutes, in this 9 minutes and 29 seconds.
The
park's still sitting on the car.
Look at my face, man.
I believe so. We found a pipe. Get out of the car.
I hate you to this real. Please. Please.
Two other people with
Please, I can't breathe. Please, man. Please. Mama.
On a weed pipe on him, there might be
Mama.
something, so that might be like
I can't. I'm bad.
Is that the
All right.
shaking of the eyes, right? Is PCP?
My knee. My neck.
Or the eyes like shaking
I'm
back and
through.
forth like that?
I'm through.
So reasonable police officers discuss the scene. The first clip, they're talking about the two other people that are over at the car, right? What's going on here? What are we dealing with? Is this person under the influence of a controlled substance? These are the actions of a reasonable police officer. A reasonable police officer would rely on his training and experience. Call EMS. Possibility that a suspect who was struggling with us will begin to struggle again. You've heard this testimony from multiple police officers. The risk that the suspect would present to himself if he's not continued to be controlled, and the risk that the suspect presents to other officers or citizens if not continued to be controlled, if he's not continued to be controlled, right? These are things that all of the police officers have testified about. These are what a reasonable police officer should do. A reasonable police officer in this situation would call EMS.
I wonder if he actually believes Chauvin is innocent.
8/20/11. within a minute of the struggle. EMS code 2 for a mouth injury, right? Because
Khalil, they just have separate trials.
Life-threatening. A reasonable officer is not observing life-threatening injuries at this point. They just fought with the man for a minute. He continued to kick at them when they got him on the ground. They see he's got a mouth injury. We need EMS. So a reasonable police officer would evaluate the injuries of the suspect, compare words and actions, and respond by calling EMS. Non-emergency. But again, reasonable police officers evaluate, reevaluate.
My brother just texted and had a very good point about what was happening. See, people watched that video of the struggle in the cop car, and the only thing that we saw, people who are reasonable, as he sits here talking about reasonable officers, the only thing that we saw was a dude legitimately having a panic attack and them killing him. That's what it boils down to.
2021, 8:21, 1 minute and 24 seconds later. We need EMS here faster. Code 3, 3:30. We need him here faster.
Yeah, because, oh shit, we just killed this guy.
A reasonable police officer would take into consideration the anticipated time of a emergent response. You heard from Genevieve Hansen. There's a firehouse a few blocks away, and she would have expected EMS to be there within minutes. 3 minutes is what she said. A reasonable police officer, based on his training and experience, is going to have and take that into consideration. I put this person in a prone position on the ground. I'm holding them for my safety and their safety. I'm expecting someone to be here within 3 minutes.
I'm kneeling on their neck for my safety and their safety.
I have called for that help.
The fuck?
A reasonable police officer will take into consideration, again, his training, his experience. Right?
Really?
Lieutenant Mercel talked about, and many people talked about, many of the officers talked about how it is not uncommon for suspects to feign or pretend to have a medical emergency to avoid being arrested. Unfortunately, that is the reality. Nobody likes to get arrested, and reasonable police officers know that. How many times does someone, oh, my heart hurts, or I'm having a medical emergency, insert whatever emergency, right? Simply because they don't want to go to jail. A reasonable police officer will take his training into experience. And you heard Lieutenant Mercel specifically say that when someone says that they can't breathe, but they are talking, if they're talking, it means they're breathing, right? If they're talking, it means they're breathing. And again, compare that to the testimony of Dr. Tobin, who told you that same thing. That is true. If you are talking, you are breathing. It doesn't mean effectively. And Dr. Tobin described how...
Oh yeah, skip past that real quick. Not effectively, but let's keep talking about how if you can talk, you can breathe.
Even medical doctors
fucking clown, man,
have problems sometimes assessing the legitimacy of a patient's needs relevant to their respiratory processes because they're saying, I can't breathe. And some doctors confuse it for just anxiety or this or that. So if medical doctors make these mistakes, Dr. Tobin told you it provides a false sense of security, right? Lieutenant Mercel told you that that is what is said among police officers. He's the trainer. So, how many times do we hear an officer say, based on his training and experience, if you can breathe, you can talk. If you can talk, you can breathe. Excuse me. I counted 7.
I can't choke. I can't breathe, Bobby. Please.
You're talking. Sit down.
Fine. Bobby. I know I can't breathe. I can't breathe.
You're talking and oxygen can't breathe.
I think.
For real. How many times must you say reasonable officer for a motherfucker who isn't a reasonable officer?
I can't breathe.
You're doing fine. You're talking fine.
I can't breathe. I can't breathe. Please. I can't breathe, officer.
You're talking. A lot of yelling.
They will give me, man.
Takes a heck of a lot of oxygen.
It's gonna be completely and fucking utterly just a catastrophe in the like in their head for them to try to think that if he continuously says reasonable officer that they'll believe it, given the fact that this dumb motherfucker keeps playing the video of George dying. It's gonna be very hard. Very hard.
Reasonable police officers, again, are trained and take into consideration a person's actions relevant to their words. Their training, their experience. Takes a lot of oxygen to talk. Takes a lot of oxygen. You're breathing fine if you can talk.
I can't breathe.
He's talking, so he's fine. Okay. We tried that for 10 minutes.
That's some bum-ass shit, bro. Y'all know that. Okay.
He's talking, he's fine.
Bro, he ain't
Okay. All right, we're done.
You certain.
Okay, we're done.
Reasonable police officers will take into consideration their training and experience on excited delirium, and they will analyze it within the context of this case.
Oh, look how violent the bystanders are. That little 9-year-old girl looks like she's ready to pop off on every officer there.
I worry about the excited or delirium or whatever. That's why we have EMS coming. It's not just leave him here. It's we have EMS coming. And this is why we have EMS coming.
And if you gave a shit about his well-being, you wouldn't have been on his fucking
Reasonable
neck.
police officers, throughout the course of a control technique, will continue to assess the level of resistance. And remember what Lieutenant Johnny Mercil said. Simply because a person isn't kicking at you or punching at you or biting at you, it does not mean that you can't control them physically with your body weight. This is at 8:24.
Yeah, somebody can't breathe and they want to fucking breathe. They're going to fucking struggle to try to fucking breathe. You goddamn stupid ass motherfucker.
Where Dr. Tobin testified that Mr. Floyd had an anoxic seizure, right? But it's not, we're not analyzing the use of force from the perspective of a doctor with 46 years of medical experience who had 150 hours of time to watch an event from multiple perspectives over and over and over and over again. It's a reasonable police officer standard. How would a reasonable police officer interpret this? Does a reasonable police officer even know what an anoxic seizure is? A reasonable police officer will interpret this as at least some form of minimal resistance. Reasonable police officers, again, are continuing to monitor. They're expecting EMS to arrive.
I see smoke in the comments. I'm just taking that as a sign to roll up.
Non-deadly force is included. It includes, but it is not limited to, physically subduing, controlling, capturing, restraining, or physically managing a person. These are the policies of the Minneapolis Police Department. Reasonable police officers, again, continue to monitor. See if he's breathing.
I think he's passing out.
He said, yeah, I think he's passing out.
Yeah, I mean, my knee might be a little scratched, but I'll survive.
I'll survive. Yeah, you will.
I think he's passing out, but he's breathing, right? This anoxic seizure occurs.
Shut the fuck up and let the video play, bitch. He trying to talk through the crowd.
Are building and basing their decisions
that.
based on all of these factors coming in at multiple times, including the bystanders. Right? Call them a crowd, call them onlookers, call them bystanders. It doesn't matter what term you use for the people that gather to watch what police do. Reasonable police officers are cognizant of and aware of their surroundings. And before I really kind of start talking about the crowd in some limited detail,
yeah,
I have thought a lot during the course of this trial about the difference between perspective and perception. Perspective and perception are two distinct concepts. Perspective is the angle at which you see something. It's your perspective. Perception is how you interpret what it is that you see. I've thought about this a lot during the course of this trial because this situation here in the courtroom is incredibly unique, right? It's not the normal setup for a jury trial. So my perspective through the course of this trial, sitting in this chair, is that I cannot see 4 of the jurors. Very limited opportunity to observe the jurors. They probably can't see me either. Several of the jurors I have a very good view of. 4 of the jurors I don't, and obstructed views of others. My perspective sitting in this chair when witnesses, there's a camera blocking the head. So in order for me to see the witness, I have to roll all the way over to the other side. Then I have to look through the plexiglass that has these large reflecting lights. Right? Things block your perspective. Things can affect your perspective. But your perception is how you interpret what it is you see and what it is you experience. And that is our life, right? This is our experiences. These are the things that make us who we are. 3 people in this trial went to the same high school. Me, Darnella Frazier, and Chief Arredondo. We all went to the same high school, obviously at different times. My experience, Chief Arredondo's experience, Darnella Frazier's experience, all based on, we had the same perspective, sat in the same classrooms, saw the same chalkboards or whiteboards, the same perspective, but our perception of our experiences there is going to be much different.
Now this nigga talking about high school.
Ultimately, at the end of the case, when we're done with these arguments, the court will instruct you on how to deal with these biases and the perception issues. The court's final instructions will guide you to try to recognize your biases, recognize them, what we bring to the table, and analyze the evidence from the perspective of the evidence itself. So let's look at this incident on May 25th from the perspectives and perceptions of simply just 4 of the bystanders. Right? Charles McMillan, 61 years old, 3rd grade in education, grew up in the South. He described himself as a curious guy. He likes to know what's going on in his neighborhood, so he stops and he checks things out, right? his perspective, he's the first one who's dealing with these guys. He has more information because he sees the entirety of the situation. But his perception of the event is affected by his life's experiences. At the end of the night, ultimately what he said to Officer Chauvin was, I hope you get home safely, because that's what he says to police officers every night.
Can you advise the fire department if they're still with you, they need to go to 36 Park to assist with the feeding of arrest?
That's one person's opinion.
But no, I gotta get
We gotta control this guy because he's a sizable guy.
Yeah, and I gotta get in the car.
Looks like he's probably on something.
But I'm just saying, I was bad, but no.
Typical white shit. He looked like he was probably on something. I was terrified for my life.
You have a good night. You go home safe with your family. They'll keep you safe.
Darnella Frazier. She's a 17-year-old high school student who, upon seeing the restraint of George Floyd, her response was to pull out the cell phone and start recording, and then subsequently upload it to Facebook, right? Her perception of the event and her perspective of the event. She's looking, she didn't even know that Officers Lane and King were there because her perspective was blocked by the squad car. But her perception, her response to the situation was to record it, and that's perfectly fine. But she began her recording at 8:20 and 51 seconds. Donald Williams. He's a 33-year-old professional mixed martial artist who arrived at 8:22 and 39. He had spent the day fishing with his son, stopping for a drink when he became aware of the incident. He described his view of this based upon his perception as a mixed martial artist, right? He has a set of experiences that caused him to react in a different way. What he perceived was happening was that Mr. Floyd was being choked with a blood choke. I think we're past this at this point. The paramedic reached in, touched the carotid artery. To have a person rendered unconscious through a choke requires the blockage of both carotid arteries. This was not a neck restraint. This was not a chokehold. He was upset. And that, again, is okay because his perception affected what he was seeing. Genevieve Hansen, right? 27-year-old female firefighter for the city of Minneapolis. She testified that when she walked into the scene, she described the crowd as upset. She said, I walked into an upset crowd. She said that the other voices distracted me from getting the officer's attention. And she testified, again, based on her perspective, that Officer Chauvin appeared to have his hand in his pocket. She observed what she believed to be blood on the from Mr. Floyd's face being pressed into the pavement. She observed fluid coming from Mr. Floyd's body that she presumed to be urine. She testified that nobody ever told her that EMS or an ambulance was on the way. She asked about, when I asked her about the response time she would have expected, 3 minutes. When I told her that paramedics had been called about 5 minutes prior to her arriving on scene, no way, because her perception is 3 minutes. But when you look at the things that Miss Hansen saw, whether it be from her perspective or her perception, there can always be more to the story. The blood coming from Mr. Floyd's nose was why they called EMS in the first place. You've seen the pictures. He injured his nose during the struggle, or his face during the struggle in the squad car. The fluid that she described as potentially being urine, we know that that's fluid coming from the undercarriage of the squad car.
I cannot breathe.
What does this have to do with the knee on the neck, fam? Jump through every hoop and hula hoop in the goddamn world. Get to the shit.
Officer Chauvin specifically told her an ambulance was coming when she first came on scene.
Don't come over here. Don't come over here.
Off of the sidewalk.
Yeah, we need you to keep some distance. Yeah, we got an ambulance coming.
Yep, we got an ambulance coming. The computer-aided dispatch reports clearly show what time EMS was called. So Genevieve Hansen has a perspective and a perception. And what she observed was not consistent with the actual evidence. But remember, we don't look at this incident from the perspective of a bystander. We do not look at this incident from the perspective of the people who were upset by it. We look at it from the perspective of a reasonable police officer. A reasonable police officer, when confronted with these bystanders, would know everything that had occurred up to that point. 20 minutes, 25 minutes, 30 minutes. They know all of that information. The bystanders do not. A reasonable police officer would understand that his actions were actually being recorded. Take the bystanders out of it. Officers wear cameras for a very specific reason, to record their actions.
They don't give a fuck about that shit.
Being recorded. Officers are aware of the placement of city cameras.
Are they? Please explain. I can't wait for him to explain all this. Because, yes, they are aware they have on body-worn cameras, which is why they know the angles in which you can actually see some shit and don't see some shit. Cops are aware of street cameras, which is why they know the specific places they can bring your ass or how they can position themselves to try to plant some shit on you. You know how many times we done seen the police plant some shit on somebody knowing that they have body cams on them? Stop playing.
Cameras. You're in a high retail, you've got gas stations, restaurants, convenience store, high surveillance. Right? Reasonable police officers know this. They would know if citizens take out their cell phones and start filming.
Prosecution, Loke.
This is the point at 8:20 and 49 seconds when Ms. Frazier starts recording. Reasonable police officers are aware when they're using force that sometimes what they are doing does not look good to the general public. A reasonable police officer will hear the frustration growing. Right? A reasonable police officer will hear the increase in the volume of the voices. A reasonable police officer will hear the name calling, right? Chump, whatever names are being called. They'll hear the cursing. They'll hear this.
They're pussies.
Take that into their consideration.
They're pussies. They're bitch ass niggas. They're cowards. That's what they are.
A police officer will rely on his recent training. A reasonable police officer will hear what I'll come back to the training. A reasonable police officer will hear what the crowd is saying. He will compare his actions to what they are saying, and he will determine, I know I'm being recorded, right? I know I'm being recorded. They're saying that I'm doing something that's awful looking. Am I doing this?
Right.
He is human, bro.
He's getting nose.
You can put him in the car. That's some
We
bum
tried
ass
that
shit.
for 10 minutes.
That's some bum ass shit, bro. That's some bum ass shit, bro. Y'all know that. You don't gotta sit there with your knee on his neck, bro. Bro, he ain't crying, bro. You circulate like in a jiu-jitsu move, bro. You trapped in his breathing right there, bro. Like, you don't think that what it is, bro? You don't think nobody understands that shit right there, bro? I trained at the academy, bro. That's some bullshit, bro. Right, that's bullshit, bro.
It's so hard. Like, how are you continuously using the phrase reasonable officer while showing video of him killing somebody?
He's talking. Bro,
it's going to be hard to make the jury
a bum right now. You can get him off the ground, bro.
Even have them even feel that way if they continue to see the video.
He enjoying that shit. He enjoying that shit. He a fucking bum,
look
bro.
at CHAUVIN, man.
He enjoying that shit right now, bro. You could have fucking put him in the car by now, bro. He's not resisting arrest or nothing.
You can see Officer Chauvin's body language tells us a lot, right? That's what we just heard.
Are you going to use the body language shit?
Looking around, looking down, looking over, looking around. He's comparing a reasonable police officer. He's doing what a reasonable police officer would do. He's comparing his actions, his own actions, in response to what the crowd is saying.
How can you say that with a straight face after watching that video?
A reasonable police officer, again, will rely on his training.
This is why I don't think it's gonna. This isn't swaying the jury at all.
Tactics of a crowd.
All.
Never underestimate
a reasonable person would know.
Most crowds are compliant.
This ain't swaying nobody.
Crowds are very dynamic creatures and can change rapidly. A crowd may contain elements of several types of groups. Now, I acknowledge that this is in dealing with massive crowds, protests and things of that nature. These are the tactics, but you never underestimate a crowd's potential, because a reasonable police officer has to be aware and alert to his surroundings.
So if people are screaming, you're killing him, and get off his neck. If you got off his neck, you think they fucking continue to scream, get off his neck, and you're killing him?
And what is
it's not a reasonable officer, you fucking dickhead.
Crisis. An event or situation where an individual's safety and health are threatened by behavioral challenges to include mental illness, developmental disabilities, substance abuse, or overwhelming stressors. A crisis can involve an individual's perception or experience of an event or situation as an intolerable difficulty that exceeds the individual's current resources and coping mechanisms, and may include unusual stress in his or her life that renders him or her unable to function as he or she normally would. The crisis may not necessarily necessarily result in an upward trajectory or intensity, culminating in thoughts or acts that are possibly dangerous to himself, herself, or others. Right? A reasonable police officer is recognizing that the crowd is in crisis. That all of these things, the members, the bystanders.
Hey, Hitman X, just hit the Cash App, man. I appreciate you, man, for real. Look, I do this shit. I only do this shit, so anything fucking helps, man. I'm literally only focused and thriving on, you know, this channel and this show and doing my other content and shit. So anything fucking helps. All the support, I welcome it all, man. And for real, so I really appreciate you, Hitman. Appreciate you.
The citizens, whatever you want to call them, they are in crisis. So a reasonable police officer considers his department's training. What are these potential signs of aggression that I may be confronted with? Somebody standing tall, somebody red in their face, raised voice, heavy breathing, tense muscles, pacing, right? This is from the crisis intervention training. This is what Kerr Yang testified to. These are signs that police officers are trained to look for in a crisis as potential signs of aggression. How do you respond to those? You appear confident in your actions. You stay calm. You maintain space. You speak slowly and softly, and you avoid staring and eye contact. Again, these are things that Kerr Yang discussed in terms of how to deal with a crisis. As this crowd grew more and more upset or deeper into crisis, a very critical thing happens at a very precise moment. And I cannot, in my opinion, understate the importance of this moment, the critical moment in this case. If you recall from Dr. Tobin's testimony, nobody disagreed, that Mr. Floyd took his last breath at 8:25:16. 8:25:16. What is happening at the very precise moment that Mr. Floyd takes his last breath? You're taking one piece of evidence and you're comparing it against the rest.
Fucking stupid.
This moment, 8:25:16, as Mr. Floyd is taking his last breath.
Get off him now! What is wrong with y'all? What the fuck? He got mace.
look, who you can check on him. He's not responsive right now. He's not responsive.
Look at him.
Right now. He's not responsive right now. He's not responsive right now. He's not responsive.
They're trying to save his fucking life.
Three things happen. Mr. Floyd takes his last breath. You see Officer Chauvin's reaction to the crowd is to pull his mace and shake it. He's threatening the use of force as is permitted by the Minneapolis Police Department policy. And Genevieve Hansen walks in at that time from behind him, startling him.
Startling him?
All of these facts and circumstances simultaneously.
How many ways do you have to call Derek Chauvin a bitch?
Moment. And that changed Officer Chauvin's perception of what was happening. After this point, the crowd grows louder and louder, right?
Because he's dead.
At this point now, Mr. Floyd has taken his last breath, and the question is the rendering of medical aid. When do we stop CPR according to the Minneapolis Police Department's policy? When it's not safe. You heard Lieutenant Mercil talk about this, and you also heard Nicole McKenzie talk about this. Consider Nicole McKenzie's testimony. As far as the reasonable police officer, which would include Nicole McKenzie, she discussed at length the difficulty of performing CPR in what she would describe as, or she did describe as, a hostile environment. You miss signs. You agonal breathing can be.
He didn't even perform or begin to perform any type of CPR on George Floyd at any fucking time. How is this in the goddamn conversation? Will somebody please answer that question? How are we talking about CPR when that was never applied to George Floyd at any moment? You telling me that you want people to believe that at that point, Derek Chauvin was sitting there trying to give George Floyd CPR and somebody ran up and it made him stop? Because from what I saw on video, he still had his knee on his fucking neck. Even when he took his fucking mace out, you would think if somebody felt threatened because somebody came up behind them, they'd stand the fuck up. No. He still felt comfortable enough kneeling on somebody. Let me just take my mace out to let you know I'm still not getting the fuck up. And if you get near me, if you do something, I'm going to spray you motherfuckers while still killing this man. This man is a fucking dumb ass.
Confused for effective breathing. As she testified, people in the area can affect the decision to treat a subject at the scene. She described how it is incredibly difficult to perform EMS efforts in a loud crowd, difficult to focus when you don't feel safe, makes it more difficult to assess a patient, makes it more likely that you can miss signs that a patient is experiencing something. So the distraction, she said, can actually do harm to a patient. When we're talking about this critical decision-making model, right? As Lieutenant Mercil said, he testified, sometimes you have to take into consideration whether it is worth the risk to remove the handcuffs and render medical aid. Because it's unpredictable, right? All this information is coming out of reasonable officers. The reasonable police officer standard can also be extended to Officer Chang, right? What is his perception of the crowd? You heard him testify, but you can also look at what was he doing during this time?
Jawanda.
What's that? I said, y'all go one of the store guys. Okay, let's stay put. We'll figure it out, right?
Right. You've got Officer Chang pacing, turning around 360 degrees, right? His attention is focused on what's happening with the crowd. But he also has another job, right? Reasonable police officers and how they interact with the crowd is a consideration. You can also take into consideration the reactions of Shawanda Hill and Maurice Hall.
How?
Damn, he still won't get in the car. Just sit down, dude. They gotta push him in this car. Look, he's fighting to get out. That's total resistance. What is he doing? Now he's going to jail. All he had to do was...
Why? So, in his defense, this wouldn't even be something that he would consider as reliable, because of how they're across the street watching from across the street, even though we see body cam footage of what's actually happening in that fucking vehicle. How could you even bring this up into your fucking consideration? Like, this dude's talking about we have to look at everything but you have continuously brought up random clips in the past half hour. You reaching. Yeah, drink that water, you nervous bitch.
They still fighting him. Hey. Oh, man, what is he doing? Oh, they going all around.
Non-police officer and their reactions to what's happening. But also consider the paramedics, right? The paramedics. They did the load and go, right?
Verdict might happen tomorrow.
As Derek Smith testified, he got out of the ambulance. He checked all four corners to gauge what was happening and determined, in his words, that it was an unwelcoming environment. And he told his partner they needed to move to a different location, a more safe and secure location. Remember Nicole McKenzie's testimony too. As unreasonable as it sounds, paramedics get attacked too.
But they didn't.
We have all of these different opinions in terms of the use of force, right? We have all of the opinions of Seth Stoughton, Jody Steiger, Barry Broad,
Not giving
Zimmerman,
no credit to them being professionals.
David Pluger, Lieutenant Mercel, and they all reach very different conclusions about when the force became unreasonable. All you have to know about Barry Broad is what he was talking about is this physically managing any person. His opinion was you can use non-deadly force to physically manage a person. It's all within the model of the MPD decision-making model. I found the most interesting person to be relevant to the use of force, Lieutenant Johnny Mercel, considering that he is Derek Chauvin's actual use of force trainer. So the best glimpse that we're going to get into the training of a Minneapolis police officer comes from the trainer who conducts the trainings. He's conducted hundreds of trainings over the years. He corrected the state at certain times in terms of how strike charts don't apply to restraint techniques. He said the knee on the neck is not an unauthorized move, and it can be utilized in certain circumstances. He described using a knee on the neck and back and stated that it can be there for an extended period of time, depending on the level of resistance you get. He said that once the suspect is handcuffed, it does not necessarily mean that it is time to move your leg, because when people are handcuffed, they can thrash around and continue to be dangerous to themselves and others.
Oh my God.
He talked about the ground defense program because it's safer for both the suspect and the officer. He talked about ground defense as a form of using your weight to control a subject without, and therefore replacing the need to punch or strike them. He said there's no strict techniques. You need to be fluid and adapt to the circumstances. That he personally trains officers to put a knee over the shoulder, up to the base of the neck, and he described this maneuver as routinely trained by the Minneapolis Police Department. He testified that there are circumstances that an officer would need to use his weight to continue to control a subject. He recognized the concept of awful but lawful, right? Sometimes the use of force is just not that attractive. He's experienced himself arresting people who have claimed to have a medical emergency. He explained how one way people can resist is through their words. He described how someone resisting can become passive and then become resistant again, and vice versa. He discussed how officers are trained not just to focus on the subject, but also the bystanders. He trains officers that if you're fighting with a suspect and that person then becomes compliant, it is a legitimate consideration for the continued use of force to control a subject. That if a subject overpowers more than one officer at a time, that is a legitimate consideration in the continuation of the use of force. He talked about substance abuse and how that officers are trained, right? I understand that superhuman strength is not a real phenomenon. There are no Supermen or Spider-Men, right? But officers are specifically trained that someone under the influence of certain types of controlled substances exhibit this behavior. They become stronger than they normally would. We've all heard the anecdotal stories of the pregnant mom lifting the car off of someone, right? It's not
aliens, cookies, high school, fucking pregnant women lifting up cars. This motherfucker is out of his mind. Out of his mind.
Literally describing a superhero. It's simply describing that someone is more exhibiting a greater strength. And the Minneapolis Police Department specifically trains that. He trains on neck restraints. Minneapolis Police Department has a specific written policy on the use of neck restraints, and it was permitted, even though this wasn't a neck restraint or a chokehold. He talked about how you need to cut off the blood supply for a neck restraint to both sides of the neck. He talked about how someone whose heart rate is beating faster, they go unconscious quicker, less than 10 seconds. He described the human factors of force. That is, how does the use of force affect the officer himself, his cognition, his abilities, his mental and physical state. He agreed that not using the MRT is a form of de-escalation. He described that sometimes you have to use your body weight to control a subject until the scene is code
AP, what the fuck is this goddamn tie?
He said that Minneapolis will train officers that under certain circumstances, an officer can hold a person in the prone position until the scene is safe. And he's done it himself at times. You have to take into consideration the presence of bystanders, where officers are located, and the environment that they're in. Lieutenant Mercil agreed that there are circumstances where I talked about this a little earlier ago, where you have to make a decision, is it worth the risk to take the handcuffs off to perform medical aid? He said there are circumstances where you wouldn't put someone in a recovery position, depending upon the safety of people, including the crowd.
He's on his way to the Catalina wine mixer.
While awaiting EMS, he described how crowds can make situations chaotic. He said, simply because a person is not actively resisting, that does not mean that you cannot use force. Right?
He can't wait to go to Miami after this.
Simply because someone isn't stabbing you or punching you or shooting at you, it doesn't mean that you can't use force. And that is specifically in the Minneapolis Police Department policy on the non-deadly use of force that we've looked at a couple of times.
You see how he's very specific at not mentioning the fact that he's cuffed?
The use of force is an incredibly difficult analysis. You can't limit it to 9 minutes and 29 seconds. It started 17 minutes before that 9 minutes and 29 seconds. All of this information has to be taken, you have to look at it from the totality of the circumstances. You have to look at it from the reasonable police officer standard. You have to take into account that officers are human beings, capable of making mistakes in highly stressful situations. In this case, the totality of the circumstances that were known to a reasonable police officer in the precise moment the force was used demonstrates that this was an authorized use of force.
Was it?
As unattractive as it may be. And this is reasonable doubt. Steiger talked about being
Didn't know murder was another word for unattractive.
They have 5 officers on a panel to assess whether uses of force are reasonable. Sometimes it's 4-1, sometimes it's 3-2, sometimes it's 5-0, because the reasonableness of the use of force is not an easy thing to consider. I know, again, I'm sorry, I'm long-winded. There are a couple of other things I need to talk about very briefly. I promise I'll be as brief as I can before I get to the cause of death. First is that concept of intent.
He talked this long without trying to talk about the cause of death.
With respect to counts 1 and 2, you have to address Mr. Chauvin's intent. Pay careful attention again to the instructions. Words have meaning.
If I was the prosecution, I wouldn't even go back up.
Means that the defendant either has
I'd be like, they already buried this motherfucker. We good.
Or cause the result specified, or believes that the act, if successful, will cause the result. In addition, the defendant must have knowledge of those facts that are necessary to make his conduct criminal and that are set forth after the word intentionally, intentional. It's the same, you'll see a very similar instruction. You'll see this very similar instruction twice. Intent. Did Officer Chauvin intentionally apply unlawful force? That's what you're being asked to decide. Did he purposefully apply unlawful force to another person? In count 2, you have to decide, did he purposely perform an act? Did he intentionally perform an act that was eminently dangerous? Right? What considerations do you have at your disposal? What pieces of evidence do you have? I'm going to try to go through these quickly. What evidence is there? What evidence is inconsistent with intent?
He has to hurry up because he realized he wasted too much time bullshit.
Some facts and circumstances that are important for you to decide in terms of his intent is within the context of aiding and abetting other people. First, officers know that they are being videotaped. They know they're being videotaped by themselves. They know they're being videotaped by bystanders. They know they're being surveilled by the Minneapolis Police Department milestone camera. Right? They know these things. Do you do something purposefully that you know is an unlawful use of force when you have 4 body-worn cameras immediately in the area, where you have multiple civilians videotaping you, where you know your actions are being reviewed through a city-owned camera, where there are surveillance cameras? Do people do things intentionally and purposefully when they know they're being watched? Remember, Officer Lane offered to have, when they were putting Mr. Floyd into the squad car, he said, I'll sit with you. I'll put the window down. I'll turn on the air conditioner.
Please. I'm just claustrophobic. That's it.
Well, you're still going in the car.
Anything sharp on you? I won't do nothing to hurt y'all. No, sir. Now you want to home or nothing? Nothing. I don't have nothing. Why y'all doing me like that, Mr. Officer? Please crack it for me and stuff, man. I am claustrophobic for real, Mr. Officer.
You got him?
Could you please crack it for me? Please.
Yes, I'll crack it.
Stay with me, man.
I will.
Please stay with me, man. Thank you. God, man. I didn't know all this was going to happen, man. Please, man. I just want my answer, please. I don't want to do none of y'all, man. Nothing.
You got it?
Inside his pocket real quick. I'm listening. And I understand that.
Please remember as we watch this that the entire time the defense has not brought up, hey, why was he being detained in the first place for alleged fake $20 bill? Why was he met with deadly force, aka a gun in his face for alleged $20 bill? He never mentioned that in this entire defense, this entire closing arguments. He has not said that one time. Why was he being arrested? Why did they detain? Why were they trying to bring him in for a fake $20 bill?
All right, he's good. This comes work. There's nothing worth it.
Okay.
Grab a seat. I'll roll the windows down, okay?
Please, man. Please don't do that.
Take a seat.
I'm going in, Mr. Officer. I'm going in.
No, you're not.
I gotta go in.
Take a seat.
Grab a seat, man.
Mind, I don't believe me, Mr. Officer.
Take a seat.
I'm not that kind of guy. I'm not that kind of guy, man.
Take a seat.
Y'all, I'm gonna die here.
Take a seat.
I'm gonna die, man.
You need to take a seat right now.
And I just had COVID, man. I don't want to do that.
Okay, I'll roll the windows down. Hey, listen.
Dang, man.
Listen.
I'm not that kind of guy.
I'll roll the windows down
Please,
and you
man.
put your legs in, all right? I'll
Y'all,
put the air on.
stop. Look at that. Look at that.
Not even listening.
Look at it. Look at it.
All right. I'll roll the window down 3 times. I'll turn on the air conditioning. Is that evidence of intent to apply unlawful force? Officer Chauvin confirms that Mr. Floyd is under arrest.
Take a seat. Please, man. Please listen to me.
Is he going to jail?
Listen to me.
He's under arrest right now for forgery.
I tell you.
Can we figure out what's going on?
Why did he skip past the initial struggle in the beginning?
Officer
Why did he
Chauvin made a
skip right to
decision not
Chauvin?
to use higher levels of force when he would have been authorized to do that, including punches, kicks, elbows, right? All of these tools were available to Officer Chauvin. That is not an intent to purposefully use unlawful force.
Look at this fucking turtle ass
They call
bitch.
for EMS within 1 minute of putting him on the ground. They step it up within another minute and a half. He believes that Officer Chauvin believes that Mr. Floyd's ability to speak means he can breathe, and they say it repeatedly. Remember?
This nigga need to wrap it up, Box. Wrap it up, B. You're done.
They tell him to relax.
You're the arrest guy.
All right. Oh, my God.
Sorry, go to jail.
I can't believe this.
Officer Chauvin is never swearing at him. He's not calling him names.
So? What is up with him calling? Like, what is up with him in that
All of this
shit?
stuff that we've already talked about, and I don't.
Sensitive ass, punk ass bitch.
All of this stuff that we've talked about throughout
calling
the
him names.
entirety of this circumstance
Grown ass man.
does not reflect an intent to purposefully, intentionally commit an unlawful use of force. All
Stop
of the
showing
evidence
this
shows
frowning
that
ass
Mr.
tortoise.
Chauvin thought he was following his training. He was, in fact, following his training. He was following Minneapolis Police Department policies. He was trained this way. It all demonstrates a lack of intent. There is absolutely no evidence that Officer Chauvin intentionally, purposefully applied unlawful force.
Get it together, defense.
Officer Chauvin is also refocusing the other officers, telling them they need to do things to pay attention to Mr. Floyd.
Let's get him on.
Should I put his stuff in the car? No, we need to get him in the ambulance. Let's refocus, right? Officer Chauvin
So much concern
had no
as his knee is on his neck. So much concern.
purposefully he did not purposefully use unlawful force. It's These are officers doing their job in a highly stressful situation. According to their training, according to the policies of the Minneapolis Police Department, and it's tragic.
He lost now.
It's tragic.
He's lost. Look.
They go to the hospital. They perform CPR. They call their supervisors. Was this an eminently dangerous act? Was putting Mr. Floyd an eminently dangerous act? We've heard a lot about the prone position. Consider just the basic prone position. People sleep in the prone position. People suntan in the prone position. People get massages in the prone position. The prone position in and of itself is not an inherently dangerous act. It is not an inherently dangerous act. A prone position during restraint is not an inherently dangerous act. It is routinely trained and used by the Minneapolis Police Department. The studies show, right? The Canadian studies that were referenced by Dr. Fowler. 1,269 cases, use of force, one death of a person not in the prone position. Right? These are people, they're looking at people in the prone position. 4,828 consecutive force events. No significant clinical effects on the subject's physiology. Right? We can look at all of the other studies trying to determine this question is putting a subject in the prone position, even with officers on top, even with weight on top of the person, is that inherently dangerous? And the research says no. The practical experience says says no. The prone position, when applied through a use of force, is not an eminently dangerous act because there is no evidence to support the notion that it is highly likely, that's the standard, highly likely to cause death. There's reasonable doubt about that.
This guy is full of shit, man.
So let's talk about the cause of death. And again, I'm sorry to be long-winded, but I have to address the cause of death. Because the state neglected to read perhaps one of the most important sentences.
Dude is fucking stupid, man.
And why you must read the instruction carefully. Yes, the defendant is criminally liable for all of the consequences of his actions that occur in the ordinary and natural course of events, including those consequences brought about by one or more intervening causes. If such intervening causes were the natural result of the defendant's act. Okay? So if the intervening causes were the natural consequences of the defendant's acts, he's liable. So think about it in this example. Police officer arrests somebody. He puts that person on a hot August afternoon in the back seat of a squad car, rolls up the window, turns on the heat, and leaves the person in there, right? Person dies of a heat stroke. Officer put him in there and is responsible for the natural consequences of his actions. But consider the situation where police officer arrests someone, they're compliant, they go into the back seat of the squad car, they're sitting in the back seat of the squad car, and they have a heart attack. They have a pulmonary embolism. They have a brain aneurysm. Something happens to that person that was not the natural consequence of being arrested. It was just a physiological something that happened to that individual. The officer is not liable because it's not in the natural course of events. And it's not the natural result of the defendant's act. Right? So again, read the entire instruction. The significance of this instruction, again, is that it goes through all of the 3 charges. You have to be convinced that the defendant's actions caused the death of Mr. Floyd. And throughout the course of this trial, the state has tried and called numerous witnesses to try to convince you that asphyxiation is the singular cause of death. The singular cause of death. And why is that? It's because actions that happened before Mr. Floyd was arrested that had nothing to do with Officer Chauvin's activities are not the natural consequences of the defendant's actions.
He's going to try his hardest.
You have to focus on the consequence of the defendant's acts. And so the state has tried to convince you beyond a reasonable doubt that the stress of being arrested and the adrenaline produced as a result of Mr. Floyd's physical resistance played no role. This is what they have to try to convince you. There's no role of that physical exertion. Played no role in this death. They're trying to convince you beyond a reasonable doubt that Mr. Floyd's heart disease played no role in this case. The state must try to convince you beyond a reasonable doubt that Mr. Floyd's history of hypertension played absolutely no role in the cause of Mr. Floyd's death. The state must convince you beyond a reasonable doubt that Mr. Floyd was not experiencing excited delirium that contributed to the cause of his death. The state has to convince you beyond a reasonable doubt that Mr. Floyd's paraganglioma was not contributing to the cause of death. The state must convince you beyond a reasonable doubt that Mr. Floyd's toxicology played no role in his death. Right? The state would have to convince you beyond a reasonable doubt that a combination of these pre-existing issues did not contribute to Mr. Floyd's death. That is why the state has brought in expert after expert after expert to testify that the singular cause of death here is asphyxiation. Because if Mr. Floyd was asphyxiated as a result of the police restraint, he is liable for the natural consequences of that restraint, of his actions. But if any of these other factors come into it, if any of these other factors were substantial contributing factors of Mr. Floyd's death, because they were not the natural result of the restraint. If a person has drugs in their system and that drug causes an overdose in the context of the police restraint, it's not the natural consequence of the restraint, it's the natural consequence of the deceased's actions. So the state has called 6 experts, really 5, but I'll include Dr. Baker. The state first called Dr. Tobin, a pulmonologist. Dr. Tobin said that you need to apply common sense to the evaluation of the medical testimony. He testified that Mr. Floyd died exclusively from positional asphyxia, coronary artery disease, hypertension, controlled substances. They played absolutely no role in the death, according to Dr. Tobin. The state called Dr. Eisenschmidt, a toxicologist, to explain to you that Mr. Floyd's toxicological levels were somehow more consistent with a DWI case than a whole bunch of other cases that may or may not have involved an overdose, right? Remember the ratio where you said, well, no, these are cases, they may have died of something else. They may have died of a gunshot wound, but they had fentanyl in their system. So he gave you these strange statistics, but essentially attempting to try to convince you that these levels are insignificant. People drive their cars around, right? And that therefore the drugs played no role in the death of Mr. Floyd. Third, the state called Dr. Smock.
Well, you're not
an
dead,
emergency
Mr.
room
Nelson, and I
physician,
know you just did an 8-ball this
to
morning.
explain to you that Mr. Floyd was not experiencing any symptoms of excited delirium. And that coronary artery disease, hypertension, controlled substances, none of that comes into play. He called Dr. Thomas, a pathologist, to testify how she interpreted what Dr. Baker meant. How she concluded that Dr. Baker simply said that the cardiopulmonary arrest is the basic way everybody dies. And she interpreted the reason why Dr. Baker put those factors on his autopsy or on the death certificate were merely for statistical purposes. You put stuff, the CDC requires us to put that stuff on there. And it was an asphyxial death. Controlled substances played no role. Hypertension played no role. Coronary artery disease played no role. They did call Dr. Baker. We'll talk about Dr. Baker in a minute. And finally, the state
He is
called
trying
Dr.
his
Rich,
best to just lag this
cardiologist who
shit the fuck out.
concluded that despite a 90% narrowing of the right coronary artery and a 75% narrowing in the left anterior descending artery, despite an enlarged heart and a history of hypertension, that Mr. Floyd
Khalil,
had
he
a
can't,
strong
or else
heart,
that'll prove the point that
and that none of
Chauvin
those
killed him.
pre-existing and coexisting conditions in any way contributed to the death of Mr. Floyd. I submit to you that the testimonies of Dr. Tobin, Eisenschmidt, Schmock, Thomas, and Rich, it flies in the absolute face of reason and common sense. It's astounding, especially when you consider the actual findings of Dr. Baker, right? Because Dr. Baker is the only person who actually performed the autopsy in this case. He's the only person who performed the actual autopsy. He told you that he specifically avoided watching the video because he didn't want to bias or influence his autopsy.
Well, he is getting a book deal.
He specifically testified that there was no evidence of asphyxia. There were no evidence of petechial hemorrhaging. There was no bruising to the neck or back above the skin, under the skin, or into the subcutaneous muscles of the neck and back. And he would expect to see those things in a case like this. There was no finding that pressure was applied to the point of Mr. Beck to cause these injuries. There were no injuries to the structures of his neck, and that when he finally did review the video, it didn't appear that the placement of the knee affected the structures of the neck because Mr. Floyd could lift up his head, turn his head, move it around. He saw no fractures to the structures of the neck, including the hyoid bone. There were no soft tissue injuries to the sides of Mr. Floyd's neck. There was no hemorrhaging or injury to the hypopharynx. No evidence of life-threatening injury to the neck or spinal column of Mr. Floyd.
They showed whole pictures of
pulmonary
George's
edema,
injuries. I don't get
swelling
why
of the
this guy
lungs,
is.
which could
He's
be
really
caused
that
by
dumb.
the resuscitative efforts or fentanyl. There's no evidence of hypoxic changes to the brain. There's no evidence of any brain injury consistent with an asphyxia death.
You know what also is very apparent and truthful in the situation is that nobody knows if George Floyd would have died that day or not if he'd never been encountered with the fucking police. Say that.
He found paraganglioma, and he said it was an incidental finding. He said his heart was enlarged. Mr. Floyd's heart was enlarged, right? Dr. Baker, Dr. Thomas, Dr. Rich, and Dr. Fowler all agreed. He found narrowing of the right coronary artery, 90% narrowing. He found 75% narrowing of the left anterior descending artery. He's the person who did he sent out the toxicology samples. Fentanyl level at 11 nanograms per milliliter. methamphetamine at 0.19 per millimeter. All of these findings that are ultimately relied upon by all of these other experts were done by Dr. Baker. He determined that the manner of death was a homicide, right? Homicide, homicide, homicide. But read the definition again of the medical definition of homicide. It is to be emphasized that the classification of homicide for the purposes of the death certificate is a neutral term and neither indicates nor implies criminal intent, which remains a determination of within the province of the legal processes. Right? The fact that he found this a homicide is a medical term. Dr. Fowler talked about the undetermined manner.
So if I went to trial and I got I got ruled my shit a homicide, I can just say that's just his observation.
Could not be determined is a classification used when the information pointing to one manner of death is no more compelling than one or more other competing manners of death in or through consideration of all available information.
This is ridiculous.
Dr. Baker found the immediate cause of death and the other contributing factors. Cardiopulmonary arrest complicating law enforcement, subdual, neck restraint, and neck compression. Other contributing factors are arteriosclerotic and hypertensive heart disease, fentanyl intoxication, and recent methamphetamine use. The term complicating in this is important because Dr. Baker was able to give you what he said his actual intent was, right? Dr. Thomas speculated about what she thought Dr. Baker meant. Dr. Baker was able to tell you what he meant. He defined complicating as an intervention that occurred. An intervention occurred and there was an untoward outcome on the heels of that intervention. And he gave you a specific example. He described a person having a hip surgery.
Oh, now we on hip surgery, huh?
Is a yes.
Blood clot.
Hip surgery, huh? Hip surgery, huh?
What I understand his testimony.
Fuck out of here.
What Dr. Baker was saying was that there was an unexpected result. The death of Mr. Floyd occurred during an event where you would not generally expect such a complication. Subdual and restraint. He specifically testified. Dr. Baker specifically testified.
Dr. Basic.
That if he put it on the death certificate, it played a role in the death. If something is insignificant to death, you don't put it on the death certificate. So Dr. Baker's conclusions that Mr. Floyd's arteriosclerotic and hypertensive disease played a role in the death of Mr. Floyd. Dr. Baker concluded that Mr. Floyd's fentanyl intoxication played a role. Dr. Baker concluded that Mr. Floyd's
he getting sleepy, he fucking up.
Methamphetamine use played a role. Right? Dr. Baker described that this death of Mr. Floyd was a multifactorial process. A multifactorial process is how he defined it. No single factor, one over the other, played any more of a role resulting in Mr. Floyd's death. He said his heart simply couldn't handle it within the context of the subdual and restraint. Apparently, the state, as they just argued, wants you to believe what you see. And they did not like Dr. Baker's conclusions. And you can see the process Dr. Baker talked about when he had several meetings, right? This happened in March. It happened in May. June,
he don't know shit.
July. By August, talk to a pulmonologist. Talk to emergency room doctor. not within my area of expertise. Talk to a cardiologist, right? His findings didn't support the notion that what you see is what you should believe. And so the state did that. They went and hired Dr. Tobin, right? A pulmonologist. Now, despite all of the information that Dr. Baker has concluded or found during the actual autopsy, Dr. Tobin concluded emphatically that Mr. Floyd's death was the result of positional asphyxia, right? The pressure of the asphalt, pressure of the weight of the officers, the positions, all of this resulted in hypoxia, low oxygen to the brain. Mr. Floyd was asphyxiated through positional asphyxia. Remember at the beginning of my remarks, I asked you to perform an honest assessment of all of the evidence in the case. And I'm going to submit to you that with no other witness should this be more carefully analyzed. I want to illustrate two brief things